Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Is that correct?
That's literally not true.
I didn't ask you to interrupt me. Oh, for Trump's sake.
Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Tuesday to you. Mental note, day before garbage day. I have to remember to take the garbage out tonight. Somebody remind me, just text me, take the garbage out, quick. All right, welcome one and all. Good to have you here. Happy Tuesday. It's been a morning already. It's been an amazing morning. My kids, I need some light. There we go. Okay, see now. My little kids, I call them kids. I don't, children, but kids are baby goats. They're super excited about their new e-bike. So I think I've ridden on it for about half a mile. The other 9 miles were them. So even the smallest one, who weighs just a little bit more than the bike comes in about 67 pounds. He can ride it. It comes to his shoulder when he stands next to it. He's a whiz on it. So amazing. All right, lots of fun. Maybe we'll do a video about it. Let's see. Only 5 more months to my new pink courthouse, says Lynn in South Carolina. Yay, love it here. Thank you, RA, for making this a safe, fun place to watch court. Lynn, it wouldn't be the same without you here. Thank you very much for that. Welcome. Greeners says, good morning. We may not make the same mistakes we made yesterday. At least we can aim not to be the cause of a mistrial motion. We're aiming high, Greeners. You know, that's our goal. We're just gonna let us not be the cause of the mistrial. That's our goal today. I think we can do that if we all work together. Greeners, thanks for helping us aim high. Mindy FS says, I can't wait until I get up my pink courthouse. Love the community. 19 months. Mindy, you're close. OG, both of you, live in South Carolina, as well as Mindy FS. So great. Welcome. Oh, I'm so excited. This morning, okay, Magistrate, this is what I want to talk about. This morning in the Karen Reed trial, we expect Mr. Alessi to at least make an attempt to argue a motion which he's been ordered to file in writing, which he probably did late last night. It hasn't shown up on the docket yet, which is basically his version of, Judge, that was weak. Specifically, that instruction. That was terrible. Going back and watching the questions.
Happy birthday. You look good.
We need to do that. Yes, thank you, Judge Fleischer, for the reminders. Corey Richards' motion was denied in Utah. Do we have a schedule yet on that one, Tisha? Let me know if you see what the actual court start date is on that. The other KR, Corey Richards. Going to be an interesting trial. Anyway, it's going to start off spicy this morning. It's going to be good.
I don't like podiums, Your Honor.
All right. Do we have any birthdays to celebrate before we kick off court? As the fan's frozen. I just kicked it. I restarted it. Hopefully that helps. Just give it a push. Nope, it's stuck again. Somebody swat the fan for us. Just reach up there and there we go. Thank you. All right. What about Alessi? You distracted him. Yeah, Alessi's going to make an argument. He's going to try to make an argument with the judge. The judge didn't want it argued. She's like, put it in a filing. Why does she want it in a filing? Because she could just say, I read the filing, denied. And it doesn't look nearly as bad as when it's argued on national television. And then she denies it. I'm just saying. It's going to be argued here, and then it's going to be argued on appeal if she gets convicted. So, all right. Morning. Any birthdays this morning?
Talking about stuff that is not relevant.
Any birthdays? Just looking through the list. We have apparently some. Here we go. Samantha, thank you very much. Meg, Jesse, Mason, who is 2, all celebrating the birthday. We're going to sing. We're going to sing to Meg, Jesse, and Mason. How do I say? When I say we, yes, that means you two. We're all going to sing. And don't worry if nobody can hear you. I can hear you. I have special powers. I can tell if you're singing or not. And you don't want to be that one person. Yesterday we had one. They were new, but they didn't sing. Don't be that person. Don't be that person. So, chat's not on screen. Well, let me fix it. Allison Gunnell, congratulations. You are the winner of the internet. First thing you fixed was getting chat on screen. Thank you. Allison, you were first in chat. Usually that's a good thing. For us, it's not. We like our peace. We like our silence in the morning. We like a little bit of solitude and serenity to kick the day off, because we know it gets crazy after that. But you interrupted that with a quick "Hey y'all," and then a whole bunch of X's. And we're going to punish you for your promptness and sentence you to internet ownership. Everything IP-related worldwide is your responsibility until we go live again this afternoon. So that should learn you, Allison. But thank you for being here. Appreciate it. All right, now we're going to go back to the birthdays and get those celebrated appropriately. Meg, Jesse, and Mason. Meg and Jesse are mine, says Selena Kate. Awesome. Let's see. I think... Uh-oh, there's another buffer. Magistra. We already talked a little bit. Magistra's fired up on your birthday. All right, we're going to sing to Magistra, Meg, Jesse, and Mason. There we go. Thank you for the correction. And, who's Lil Beckett? Who's Lil Beckett? Y'all need to learn how to get these on the list a little sooner, because I'm getting confused here. Is Lil Beckett one?
Happy birthday. You look good.
Waiting. Yeah, I don't know if Lil Beckett is one or not. I saw it on the screen. Now I can't find it. So, all right. Magister, Meg, Jesse, and Mason, we're going to sing to unless we get instruction anywhere else. And what we're going to do, everyone stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbors. Warm up with me if you will. La 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 la. There we go. A couple more. We're adding as we go. All right, we're going to sing together. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Meg, Jesse, Magistra, Beckett, Mason, and Lindsay. Happy birthday to you. Meg, Jesse, Magistra, Beckett, Mason, and Lindsay, happy birthday. There are many wonderful days. Today is your special day. I realize there are a million places you could have been, a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully we can turn that back to you in just some small portion and make your day a little more special. Help yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, and Bob Evans. Not a sponsor. Any of them. Hit me up. All of you. Happy birthday. Have a wonderful one. It's a Tuesday, and I realize the only thing that would have made your birthday a little better is if it were a Friday. But still, it's good. Pancakes at Ari's house. This morning was oatmeal, but you're welcome to some of that if you want. Oatmeal's good. They say the oatmeal causes or helps solve depression. I don't know. I think that's just like an old wives' tale. Eat your oatmeal or you'll be depressed. Like, I get depressed looking at this stuff. Today will not be a half a day. No half a day today. No bacon this morning. Just oatmeal. helps depression. There you go. See? I ate a lot of it. I ate a lot of it when I was over in England. Why? Because it was cheap, and I was cheap. Okay, drum solo coming up. Everybody help us finish the birthday song, get this birthday celebration kicked off in style. Beautiful. I'm becoming a better drummer in real life, at least in my head. I've not played the real drums since I started live streaming, but in my head, I'm a better drummer now because of the morning drum solo. Thank you all for helping with the birthday celebration. The music was incredible. 80s music, man. We heard you. The big finish, the cymbal. I'm not sure what brand you have, but it just rings and rings. It's brilliant. All right. What's the bet? The judge has said today, no sidebars, right? We're not going to waste, jurors, we're not going to waste your time tomorrow with sidebars like we have previously. I mean, we were doing important stuff, but we all know it wastes your time, and we're not going to do that tomorrow. So there will be no sidebars. There will also be no objections. We're just not going to have any objections and no sidebars. I don't know how it's going to go. I don't know, but I predict a sidebar to start. That's my prediction. I know she says she doesn't like it. Remember when I told you yesterday as you left that we were ahead of schedule? Well, it turns out that the defense, not going to name any names, but the defense has caused some delays. And as a result, you're going to have to be here another week and a half, possibly 3. It's funny. Miss Gruens, I'm giving her a hard time because I'm a little upset with the judge's ruling. I
think I'm about to catch a whooping.
Yeah, I'm probably going to catch a whooping for it. I've defended a lot of the judge's decisions and had to, even the ones I disagreed with Judge Beverly Canoni. I've looked at them. I've tried to say, let me see if I can look at it from her perspective, right? And this is a difficult mental gymnastics effort for me. Let me look at this with her eyes type thing, right? And sometimes I'm able to do that. I'm like, I can see in the right situation or coming from the right angle, I can see why she said what she did, or I can see why she ruled the way she did. I'm struggling on this last one. I'm really struggling. I just do not believe that Mr. Brennan is being truthful with the court when he says he just, I was so rushed to take the case, I just had a chance to just flip through the files, and some of the documents jumped out at me, and most of them I just wasn't able to read. Didn't even have a chance to review the evidence very much, and so in my haste, I made a mistake. And oops, I manufactured evidence in front of the jury. My bad. And the fix for that, because all that confession happened outside the presence of the jury, the fix for that is, jurors, the lab tech did it. Continue. It doesn't balance for me is the problem. It doesn't balance. What let's see, Ms. Grins, judge in Cuz's case ruled no streaming last minute. Oh, anything you can do to change that? No. No streaming. What you can do, all of you can ask to log in and watch it on the Zoom, even though you're not streaming it. I don't know. The judge has complete discretion in many states. It's terrible. Bonnie, yes, I'd probably start with the Nocta macro simplex. It was the NOKT Noctra. I can't misspell it. Noctra macro, I think is what it is. A simplex is the metal detector brand. $200-$300-ish. All right. Anyway, I'm just a little bit upset. I know Mr. Alessi is still upset. He told the judge, look, we're not happy with the solution. And she's like, well, you had me change it. He's like, yeah, I suggested a change. And you said, never mind. I don't like your change. I'm just going to make it even shorter. and then you abbreviated that and called it good. So, yeah. Anyway, what I don't know, I didn't get to see Peter's coverage last night. What I don't know, and I'd love to hear from a legal mind familiar specifically with possibly Massachusetts court rules. Will the defense be allowed to bring this up on closing? This happened in front of the jury. This isn't like a surprise, right? This isn't like, oh, the jury shouldn't know this. It literally happened 6 inches in front of their face in open court. It's on the record. The defense should be able to say something, right? It can't be just like, hey, I said sorry, so all's forgiven. Forgive and forget. You're supposed to forget, not mention it again. They've got to be able to bring this up and say, there's no evidence of a collision. The medical examiner doesn't think it's a car accident. We've got three experts, and some of them on the prosecution side doesn't think there's a car accident. We've got XYZ evidence, and to try to convince you, they manufactured evidence in this court that they made themselves after the fact and tried to say that was evidence. I think they should be able to say that. I think that balances the scales a little bit as far as what happened, but she didn't even strike the testimony. Yeah, it's still on the record, which should go to allow the support for that argument in closing. It should allow that. If it's on the record, it should be allowed. Can you discuss the amount of voir dires the defense has to have versus Commonwealth? It seems not weighted fairly. Is that normal? It doesn't seem balanced. Now, it doesn't need to be even to be fair. Just by nature of the case, by nature of the type of things, the experts you call might not be as specialized in the area you want them to be specialized in. And I realize if you look at the law in Massachusetts and the rules for the judge on what she can deem who an expert is and what categories, if you are looking at an expert in dog bites, there should be some level of specialized education, of specialized training, of publications, of peer review devoted just to that. And I can see that one, but just barely. I don't like it. It sticks in my craw as I say it, but I can see the judge limiting in part this doctor who has incredible experience and includes dog bites, but it's general experience. It includes just as much gunshot information as it does dog bite information, which is not specialized. I don't like it, but I see it. Anyway, please wash your craw. Yes. All right. It doesn't seem even. And I think the problem is for a lot of us looking at this, it seems to consistently fall with a slant, right? That all the rulings come down with a slant. And I mean, if you're pro prosecution, I'd ask you this: did Judge Beverly Cannoni yesterday, when she was making that ruling regarding the manufactured evidence, that's what it was. Okay, I'm not making up a word for that. He literally took evidence that the crime technician had created, meaning holes in the shirt, and presented them to the jury and the witness as evidence of road rash from a car accident. That is manufactured evidence. When she made her ruling on that, do you believe that she was looking at that through the letter of the law and what happened and ruling fairly? Or do you believe that was against her very nature and she had to spit it out because she hated saying it? Even Mr. Alessi looked away from her while she was talking because, they're still trying to, this has just happened in front of them, right? They're still trying to talk it over with counsel as she's talking, and she snaps at him. Well, if you're not going to listen, I'm not going to read it. I'm like, it shows a slant there. It shows a slant, and it can't be there. It can't. The judges have to do better. Anyway, yes, I agree. And when you put it, when you go back, and maybe Mr. Alessi will do this morning. Maybe what he's going to do is say, Your Honor, this one issue standalone. Maybe if this was the only thing that would happen, we would see it. But look back at Mr. Burgess, presented as an expert. Guess what we're not going to go into in front of the stand. First time in trial history. Guess what we're not going to go into as we talk about our expert, his education. We're just going to right over the top of that and not bring that up. Why? Because we know there's a problem. We know he lied about it. We know there's false documents that have Mr. Burgess's name and Mr. Brennan's name on them presented to the court that present Mr. Burgess as something he's not, which is used to authenticate him as an expert. That level of being willing to allow untruths to be presented in court as truths has to be weighed together with this one. I don't think you can look at everything in isolation. Eventually you have to say, we're starting to see a pattern here. Our pattern recognition skills don't just apply to dog bites and car bites. They also apply to behavior of prosecutors. And I'm starting to see a pattern, and he's getting away with stuff. All right. Now I'm riled up first thing in the morning. We need some yoga music first. Defense have misrepresented evidence to the jury as well. Lindsay, what refresh my memory what you're talking about on this one. Honestly, I'm curious. Defense insisted they didn't pay ARCA to the court, then submitted a motion saying they did, then tried to play off as some lawyers knew, some didn't. Then the message was, what about their conduct? Let's see this. The defense and the witness, when that testified, agreed that there was no contract, they had no contract, and they didn't pay them. After the trial was over, ARCA billed them for the time he spent in court. Defense paid. But there was no contract, there was no discussion to pay at all before then. They literally got a free witness and thought they had a free witness. I know a lot of people don't like how it went down, but the FBI had paid them. And they got a free witness, or thought they were going to get one, that ended up paying his time in court. The messages, you might not like it. It wasn't against the law. It might be tricky. It might have been purposefully done to irritate somebody, but it wasn't against the law. They turned over all their emails were the only thing they were instructed to turn over. They turned over all of those. They may have purposefully used something that didn't preserve their messages. The law, as the judge, tried to rip him a new one. Mr. Alessi got up and said, the law you're citing does not apply to us, period. And she's like, you're right. You win this one. You're right. It wasn't wrong. It was shady. It was sneaky, but it wasn't wrong. Let's see. I'm talking about after when they lied to the judge in a sidebar, then admitted later. About what? I don't recall them lying. The only thing I know is that the judge ruled that it was a discovery violation, that they should have turned over things they didn't have, and they paid the penalty for that. They weren't allowed to mention third-party culprits or ARCA in their opening, and that was handed out moments before their opening. Court is late. Yes, that's because the judge is reading a motion, I'm guessing. Yep, that's absolutely correct. Do you like other flavors of Mountain Dew? I'm trying really hard not to drink it. I'm deciding to be healthy again. Something about buying an e-bike and how lazy it is and how I can sit on it and just twist the throttle and take off. And the thing has a top speed of 60 miles an hour. I limited it at 20, so I can limit it to a class 2, but I can also unlimit it. So, hang on, we've got a call coming in. Just one second.
Donald King.
Donald King, this is R.A. How are you doing?
Hi, Scott. How you doing?
Good. You know, as soon as you call, the judge is going to come in. So
yeah, I'll be quick.
What's up?
There was a case in Kentucky about 5 years ago I was watching, and the prosecutor misrepresented facts. And what that judge did is he put the prosecutor, sweared him in and put him on the stand and let the defense question him about it.
That sounds remarkably similar to what happened in the Alec Baldwin case, where the prosecutor.
It was similar, but
you are unmuted.
Yep. Okay,
there were different circumstances.
Donald, they're starting right now, but it's interesting the remedies that are available. Thank you very much for the call. We'll see you.
Bye-bye.
Bye.
All right, so I received a couple of motions a little while ago. Good morning, everybody. I'm sorry. And there are some things we need to talk about from yesterday. Are the jurors here?
They shouldn't be. You told them to come late.
Okay, good. All right, so the order I'd like to do is, Mr. Jackson, yesterday you were going to take a look at any photographs you intend to put in with Dr. LaPosada?
Yes, those have been presented to the Commonwealth.
All right. Can I just, are you all in agreement, or are you just looking at them now, Mr. Brennan?
I heard specifically from Mr. Brennan, but the issues that he had, obviously we're not, at this juncture, until we're further, we're not going to bring in anything having to do with dog bites, claws, dogs in tissue, any of that information, but we are going to bring in exactly what we indicated yesterday. If there's an issue with, for instance, the ecchymosis, we've got a clean copy of the photograph without any of the narrative next to it, which is explanatory.
Rebecca, thank you very much. Congratulations on 29 months.
Which Mr. Brennan indicated yesterday he did not have to issue.
All right. So I need to know, just for instructions to the jury about, I'm concerned about the photograph on page 5, figure 3. Yes.
Yeah, that's going to be, we intend to show that. That shows the...
So what I would like you to do, if you could, is just crop the center that shows what appears to be blood cells, or the red. I assume that that's the part you want to get into? Sure. If you can crop that, I'll let it in, and I still want to give an instruction, so I need to know what you're going to do with that. I was going to exclude it, but I understand. So if you can crop, yes, if you can do that, I think it takes away some of the sting on the gruesome photographs.
Sorry, you can't just keep.
All right, so you'll do just the brainstem on that, Mr. Jackson? All right. And so I'm concerned more about the ones that I think may cause the jurors some concern. So the photograph, figure 5, the Wisniewski spots, I thought that was in evidence. I don't know for sure if it's in evidence.
We went back and forth yesterday, and I don't believe that it's actually in evidence. It is not.
Okay, so
it's not in evidence. That was
okay.
Yesterday we all assumed it was.
Yes.
I'll put it in evidence as.
All right, they've already seen it, so it's less likely to have an impact on them for purposes of the gruesome photographs. But and then on page 8, figure 6, the stomach lining.
Correct, that's already in evidence.
Okay, that's what I thought, Tori, you told me yesterday the number, right? So those are in. So are you using them again?
I'm going to use them again comparatively and probably side by side.
Okay. All right, I don't have a problem with that. Does the Commonwealth?
I don't.
Okay. All right. Those are the ones I was concerned about for purposes of an instruction. If there's objections to hearsay or something, I'll give Mr. Brennan an opportunity to take a look at whatever he's got.
Understood.
Okay. All right. So with that, that's helpful. Thank you. So there is a new motion this morning suggesting that the Commonwealth open the door with their questioning of Dr. Russell to allow Dr. LaPosada to talk about bite wounds. So I've read that.
Correct. I'd like to be heard on that briefly.
Okay, sure.
Thank you.
Let's hear Alan Jackson's best here. They really need to get this in.
I'd like to start, if I may, by marking two documents with code permission. One is Dr. LaPosada's entire report, and the second is
great.
her entire CV.
Okay. Yeah, those are the ones I needed from yesterday. So, yes. Yes.
Exhibits D, 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 and exhibits E, 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 E.
Okay. All right, go ahead, Mr. Jackson.
Thank you, Your Honor. We are asking the court to reconsider the court's ruling yesterday concerning Dr. LaPosada and her ability to opine on the issue of dog bites, dog bite and claw mark wounds and pattern recognition. We had some concerns yesterday and previous to yesterday about an issue that has been ongoing with the Commonwealth, and we've brought this to the court's attention. The Commonwealth has been using a tactic to shift the burden to the defense with cross-examination that's laced with indications or implications about witnesses that may or may not be called by the defense. That is a problem. I brought it to the court's attention at sidebar. The court will probably remember that colloquy. It was not an open court, but I expressed grave concerns, to use that phrase, that there was a burden-shifting system that was going on when Mr. Brennan is asking our witnesses about, or his witnesses, about other witnesses that may be on the defense witness list and may be called. Obviously, as the court knows, foundationally, we don't have to call anybody. We don't intend to call anybody. We don't have to call anybody, but we can call whoever we feel like. But we shouldn't be put in a position where our hand is forced to call witnesses because of questioning by the Commonwealth, which is improper. After I brought it to the court's attention, Mr. Brennan has continued along that same line. The Commonwealth has continued along that same line, and I want to bring something to the court's attention specifically. Last night, we pulled the tape. Dr. Russell was cross-examined by Mr. Brennan on the issue specifically of Dr. LaPosada and her opinions regarding dog bites. He asked questions over and over and over again. The colloquy probably lasted more than 5, 6, 7 minutes with Dr. Russell, specifically on the issue of whether or not she had seen Dr. LaPosada's reports, whether she was aware of Dr. LaPosada's opinions, implying that Dr. LaPosada had opinions about the dog bites. She was asked if she was familiar with Dr. LaPosada's credentials. Dr. Russell said, yes, she was familiar with Dr. LaPosada by name, that she thought she had impeccable credentials, and she very much wished she could have seen her reports as it relates to dog bites. It was an intellectual curiosity by Dr. Russell that was evoked and elicited by Mr. Brennan on cross-examination of Dr. Russell. She was then asked the seminal question: did the defense, Dr. Russell, give you any reports by Dr. LaPosada related to dog bites?
What page is that on here?
On the transcript?
Yes.
Oh, my motion's back at the desk.
It's like I don't have the motion I'm arguing with me. I'm just doing it off the top of my head.
Does the court have it?
Yes.
Okay. I'll just
read from the transcript.
I'll just read it. Question by Mr. Brennan to Dr. Russell. And so you think of all those forensic pathologists, medical examiners, You think that qualification and experience itself is not enough to qualify someone to give an opinion on a photograph about the genesis of a wound related to dog bites? Answer. Well, if a forensic pathologist autopsied 1 or 2 cases of dog bite wounds versus my experience with over 500 to 1,000 cases of dog bite wounds, I'm not sure that person would be a very good expert in that kind of case. Question by Mr. Brennan. Have you ever heard of a doctor named La Posada?
So are you going to read all 3 pages?
No.
So I've read it, Mr. Jackson.
I'd like to read it into the record, Your Honor.
It's in the record. I will put this transcript into the record. I'm not going to let you read 3 pages here.
It's not 3 pages, Your Honor. It's about another 5 lines.
The
It just goes to the top of the next
part that you
page.
brought to my attention is on page 15, not where you're reading.
The colloquy between between Dr. Russell and Mr. Brennan was specific to dog bite wounds. It was specific to Dr. Russell's understanding of whether or not Dr. La Posada had been retained by the defense, whether she was a defense expert, whether she had written a report, and whether she opined about dog bites and dog bite wounds. And after she was asked if she had been provided any reports by the defense attorneys specifically, from Dr. La Posada related to dog bite wounds, Dr. Russell said, no, I haven't been. And to summarize her statements, which the court has in front of it, Dr. Russell went on and said, I really wanted to see what Dr. La Posada had to say about these dog bite wounds. I really wanted to read her report. But no, I was never provided her report or reports by the defense. And of course, Your Honor, as the court knows, that is standard operating procedure. I don't trade reports between and among experts because obviously I want independent analysis. I don't want to cross-contaminate any opinions, et cetera, and be accused of doing so. So of course we didn't provide a report from Dr. La Posada to Dr. Russell. But Dr. Russell's intellectual curiosity was then extracted from the witness stand, and the jurors heard all of that. So then days later, not weeks, not months, 3 days later, after eliciting testimony from Dr. Russell about Dr. La Posada having a report, being hired by the defense on the issue of dog bites and not providing that report to Dr. Russell, the Commonwealth then moves to exclude the very testimony that he was eliciting from Dr. Russell, leaving the jurors with a very, very deep and irremediable misimpression. They used it tactically as a sword and a shield, and that's burden shifting. That leaves the jury with the impression that Dr. La Posada was consulted by the defense, number 1, that she wrote a report, number 2, that the report was about dog bites, number 3, that she didn't provide that report to other experts, number 4, and the reason she didn't, obviously, is because her opinion, Dr. La Posada's opinion, would be harmful to the defense. That's the only reasonable interpretation of those facts. And the Commonwealth has taken advantage of that. The Commonwealth's questioning of Dr. Russell about Dr. La Posada and her report and her opinions about dog bite wounds specifically was deliberate, and it left the jury with an open question. We know they consulted her. We know it was about dog bites. This is how the jurors are thinking about it now. We know they consulted her. We know it was about dog bites. They hid the report from Dr. Russell because they didn't want her to know about it. Ergo, must be harmful to defense. Now we've got Dr. La Posada on the stand. Her credentials are peerless, absolutely peerless. They've got possibly the most qualified medical examiner in the country, certainly on the Eastern Seaboard, right in front of them, about 6 feet away, and the defense is not going to ask a single question about her opinions concerning dog bites when she reviewed the entire autopsy. How is the jury going to conceive that? How is that going to land with them? The answer is they're going to think, they have no choice but to think, the only reasonable explanation is, if Dr. La Posada's opinion helped the defense, they would ask her. If they don't ask her, it's because whatever Dr. La Posada says about that right arm and those wounds, it's got to be harmful to the defense. They would absolutely ask the question. So the Commonwealth got to have it both ways. They got to ask Dr. Russell about Dr. La Posada and imply that Dr. La Posada had opinions about dog bite wounds. And then they have it the other way, which is, let's ask the court if she will exclude Dr. La Posada from testifying about the very issue that they brought up in front of Dr. Russell. That cannot stand. That ensures, it reasonably ensures that the jury will misrepresent or misunderstand the import of why we're not asking Dr. La Posada about her expert opinion, especially as it specifically pertains to dog bite wounds. I want to talk for just a second, and that has, by the way, that has constitutional implications. Ms. Reed is entitled to a fair trial, not a fair trial that the Commonwealth designs, not a fair trial that the Commonwealth curates, but a fair trial. Regarding Dr. La Posada's credentials, we went back through, specific to the court's questions yesterday, her resume. There are no fewer than 13 classes, 13, that she has taught specific to wound pattern recognition that have included dog bite recognition. On page 7, she was the course director for medical legal death investigation. That was in 2013. She taught about dog bite recognition in that case, or in that course. She was a thesis advisor for Master of Science Graduate Medical School, Boston University School of Medicine. Taught about dog bites. Staying with page 7. Forensic pathology, course director in pathology. Course 205. Taught about dog bites. Member of Quality Assurance Committee, Training Division of Trauma and Surgical Critical Care, teaching on the issue of wound recognition, animal bites, and specific to dog bites. Pediatric Forensic Pathology, Texas Homicide Symposium. She was a presenter in 1989. She taught about the issue of dog bites as it relates to pediatrics, children, dog bites in children. Forensic aspects of physical child abuse as related to being left with dogs that can injure a child, dog bites, dog bite recognition. These are all classes taught by Dr. La Posada on the issue of dog bites to other medical professionals. The one that stands out, however, and I'm not going to go through the other 9 or 10 or 11, the one that stands out is 2015 and 2016, 2 courses. The name of the course, Emergency Room Forensics, Evidence and Patterned Injuries, New England chapter of the International Association of Forensic Nurses, taught in Norwood, Massachusetts, both times, specific to dog bites and the issue of dog bites as seen by emergency room physicians, how they should handle them, what they should do with them, how they should view them, what to look for in terms of pattern recognition. She's eminently qualified. I will leave the court with one thought. The court indicated when qualifying Dr. Russell, one of the preeminent things that the court mentioned in qualifying Dr. Russell is that Dr. Russell utilized a methodology that the court sanctioned and quoted and said the methodology that she used of wound pattern recognition, dealing with differential diagnosis, utilizing and interpreting dog bites by the method of exactly what Dr. Russell did. Differential diagnosis is something that the court said was exactly why the court sanctioned Dr. Russell and blessed Dr. Russell as a qualified expert, and that's exactly what Dr. La Posada testified yesterday she utilized and utilizes in coming to her opinions and conclusions. Going back to the open door issue, obviously she's eminently qualified, but, Your Honor, this cannot stand. The Commonwealth cannot have it both ways. They cannot walk up and say and leave the impression with the jurors that Dr. La Posada opined about the dog wounds, but we're not able to hear it. We, the jurors, are not able to hear it because obviously that is something that is her opinion, whatever it might be, is harmful to the defense. When in truth and in fact, it's exactly the opposite. Dr. La Posada's opinion has never wavered. Those injuries on John O'Keefe's arm are from a dog, period, full stop. Anything less than presenting that to the jury at this point would be to perpetrate an intentional fraud on this jury. Ms. Reed is entitled to more. She's entitled to better. She's entitled to the evidence.
All right. Thank you. Mr. Brennan.
Mr. Brennan.
The pattern of conduct that stands out is persistent, repetitive, contrary to court rulings and court orders, and deliberate. And that is, the defense uses their witnesses to vouch for their own credibility. They use their witnesses to introduce information they know is not admissible, and they use their witnesses to introduce otherwise inadmissible hearsay. Dr. Russell took the stand, and she was led into answers where she was vouching for her own credibility. Dr. Russell promoted herself not only as an expert, but through the defense's questions, as virtually the only expert in America who has the expertise to give this type of opinion. It is the defendant's tactics that open these doors that they then want closed. The defense had Dr. Russell all but assure the jury that she uniquely was in the position to give any type of opinion regarding dog bites. Inevitably, when I asked Dr. Russell, and I began asking her about her credentials, whether she thought that she was exclusive, and I mentioned Dr. La Posada, she denied ever reading anything about Dr. La Posada. I did not specify whether she read an opinion about a dog bite. I asked if she had heard about Dr. La Posada. She denied it. And then she told us that she knew about Dr. Sheridan. Unsolicited, then added that Dr. Sheridan, involved in a previous proceeding, believed that the bites were consistent with dog bites. I don't know how she became aware of Dr. Sheridan's testimony, and since the defense doesn't speak to her about these things, she must have watched it on her own. But inevitably, she introduced inadmissible hearsay and inadmissible opinions. And so the sum zero here is that Dr. Russell has denied that she saw anything relative to Dr. La Posada, ensured that she was exclusively qualified, and introduced an improper opinion.
We're getting some... see if we can try this one.
Anything about Dr. La Posada. I did not specify whether she read as it pertains to dog bites. We asked her questions about her specific experience. She did not provide a basis, and so her opinions regarding dog bites should not be permitted in this trial.
Just to clear up the record, two things stand out about that speech.
That speech.
Mr. Brennan literally just said, I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is
Excuse me.
No, I'm not going to.
So I heard what Mr. Brennan said. You don't need to tell me what Mr. Brennan said, but go ahead to your argument.
How about if I quote his words? How about that? Question. And so you think of all those forensic pathologists, medical examiners, and you think qualification and experience itself is not enough to qualify somebody to give an opinion on a photograph about the genesis of a wound related to dog bites. The question was specific to dog bites. That's how he introduced the subject matter to Dr. Russell. Then his next question was, have you ever heard of a doctor named Dr. La Posada? Those were his words. Then he goes on, I think he also just said that he did not elicit information about other individuals, including Dr. Sheridan or anybody else. Question by Mr. Brennan. Were you ever told what other people's opinions might be regarding those photographs? That's the question that she was answering when she said, quote, I'm aware that there was a Dr. Sheridan involved in a previous proceeding, and he believed that those were consistent with dog bites. That was in relation or in response to Mr. Brennan's specific question. She didn't just elicit that. She didn't volunteer it. She said it because he asked her. And that was all by design. The entire thing has been by design. He elicited the information suggesting that Dr. La Posada was being hidden from Dr. Russell because her opinion would harm the defense. He left that with her on purpose, then turned around and 3 days later said, and by the way, the defense should be disallowed from using Dr. La Posada to talk about the very dog bite wounds that I asked Dr. Russell about. That cannot stand in this courtroom.
Go ahead.
It's helpful if you read the entire thing in context, which I won't do. We always have a right to object to an inadmissible opinion. So the suggestion that somehow an ambush here is not only misplaced, it's strategic by the defense to try to create a narrative. It's improper.
You asked the question.
All right. I'll be out in 10 minutes on this, and we'll get started right away with Dr. Laposada.
All right, the court, please.
Judge retreats to make a phone call, phone a friend. That was a powerful argument by AJ. The response by Mr. Brennan saying, he said, let's do something. Oh, I didn't record it. Dang it. Okay. We can rewind, but hold, please. Let's see. We want this one over here. Give me a second. I wanted to go over, I wish I would had it ready here. I would have pulled up what he said. I said, I didn't say dog bites. Yeah, you did. Yeah, you did. Let's see on this one.
A dog bite. I asked if she had heard about Dr. Laposada.
Listen to this.
She denied ever reading anything about Dr. Laposada. I did not specify whether she read an opinion about a dog bite. I asked if she had heard about Dr. Laposada. She denied it. And then she told us that she knew about Dr. Sheridan. Unsolicited, then added that Dr. Sheridan...
Unsolicited. But the question was, have you heard anything from anyone else about those opinions? It's full on. Brennan's caught with his pants down here. Okay. I don't know how the judge can with any degree of professionalism side with the prosecution at this point. I think they've opened the door. How far they've opened the door? Probably all the way. Yeah, this morning was going to be wild. I was wrong though. Did not start with a sidebar. Luckily, it started in open court, which is amazing. Judge taking 10 minutes to review this. Saying, "Don't read it to me. Don't read it to me. I know what he said. Don't read it. Don't say it. Don't say it, Mr. Jackson. Don't read what he said, because then everyone will know." The more egregious this becomes, the more if this goes, if she gets convicted and it goes to appeal, the stronger I feel that the appeal will be granted, and there might be some rules put in place as well, like they'll be heard and overturned. I don't know. Can judges seek advice from other judges? Generally, but the other judges can't make the decision. That judge has to make the decision. We have heard of judges phoning a friend before, asking for insights or information.
Call from
Guten Tag.
To accept, press.
Is this Mathis?
Yes.
Well, I couldn't hear what your name when you called. How are you doing?
Pretty okay. I was a little bit sick last week, but it's getting better.
Oh, good to hear you're on the mend.
And I've been cuddling a lot of cats today, so that helps.
That helps. Mine clawed me this morning, so got that.
I wanted to briefly call about some of these rulings. I think that really was a good argument by Jackson. Mm-hmm. I wanted to briefly comment on another thing. There's still like one more ARCA witness that's going to testify.
Right, Rentschler.
And do you remember there was a line of questioning that was really that really confused me by Brennan, and why the defense didn't seize on that. It was something like, "Oh, you said ARCA has contracts with the DOJ and other three-letter agency that's very high profile, like was it NHL or something like that?" And then Dr. Wolf said, "Well, yeah, I think that was it." Mm-hmm. And then Dr. Wolf said, well, no, those were before my time. Oh, so you didn't work with any of those high-profile clients. And
not those ones, but with some other ones, like the FBI.
Yeah, and I thought, well, okay, redirect. Hey, Dr. Wolf, any high-profile three-letter agencies you worked with recently, like on this case?
See, the problem
is... It so opens the door.
We're back.
I think
we're back.
So I'm not going to allow Dr. Lapisada to testify regarding dog bites. Your rights are saved. I'm going to give an instruction regarding burden shifting.
Well, don't waste your breath, Judge.
I just think it's outrageous. I think the conduct is outrageous. And I don't think that a purity instruction can do anything except bring the point home yet.
Okay.
But if the court is not willing to allow her to testify to her full
nuclear.
to a reasonable degree of scientific certainty, can she at least testify that she reviewed the arm, looked at the arm, that it's consistent with an animal? Can we at least split the baby?
I will do that. I'll allow that, yes. Over the Commonwealth's objection.
Can I look to have the cross-examiner? Because if you're going to allow a consistent opinion with a dog...
No, Mr. Jackson said animal.
I'll leave it at animal if that's what I can get. I'll take what I can get.
In her experience, Mr. Jackson, you have to lay a foundation. In her experience, seeing animal bites, this is consistent with what she has seen in an animal bite.
And that will include, I'll come to sidebar before I display anything, that will include a representation of what an animal jaw looks like.
No. No, it will not.
Why is that?
That's my ruling, Mr. Jackson.
So no visuals?
No visuals, just that one sentence that's consistent with what she has seen is an animal bite. A brief foundation, because I'm letting that statement in as long as she has said, as long as she testifies that she has seen animal bites over the years. That's it, Mr. Brennan. That's what I'm doing. So you don't want an instruction, Mr. Jackson?
I want a mistrial.
Okay. All right. So there are two other quick matters, but the jury's been here, and I don't think we'll get past the break without this anyway. I may have left it in the...
Jim, can you run
I
to my
left it in my office anyway. So let's just bring the jurors in and move forward with this. All right, Paul, I'm just going to take two.
All right, please.
Wow. AJ, Klein for anything he can get there. Basically saying, as the judge gives her ruling, says to her in open court, well, without the juror there, that's outrageous. That is outrageous. Can we at least say it's consistent with an animal attack and split the baby? Splitting the baby has a reference to a biblical story where two mothers had a baby. One of the babies passed away, and both mothers claimed the surviving baby as their own. It basically goes to court over this. Goes to the king, and the king says, "I've got perfect idea. Cut the baby in half. You each get half." And one woman says, "Yes, yeah, that's fair." Okay, and he says, "It was a test. A real mom wouldn't have done that. A real mom would have said, no, let the other woman have it. Don't kill my baby." And so but here there he says he's actually, we are getting half. We're getting half. We're not getting. Brennan's not stepping up. It's not his baby. He's like, oh my goodness, King Solomon, wise king in the Bible, biblical story. Anyway, splitting the baby. We're going to get now. This is going to be feisty, okay? Because Mr. Brennan is still not happy. He didn't even get to argue against this, right? The judge will not allow any visuals. She says you have to lay a foundation, but at the same time she's like, be very brief in your foundation because I don't want you to go into all the dog bite analysis she's had and then say it's consistent with an animal attack, because that's sort of saying it's a dog bite. So we're going to see objections. Mr. Brennan is not going to think the foundation is ever sufficient. I think the judge wants the foundation to be less than it is, so they're competing against each other. Oh, wow. She literally taught classes about dog bites. Yeah. This is wild. For the judge saying there's going to be no sidebars, guess what? There are now going to be sidebars. We know of at least one. Mr. Brennan's going to come in and say, hey, well, he said, before I show anything, well, maybe there won't be. She's like, no, you're not going to show anything, so maybe no sidebar. Mr. Brennan's going to ask for a sidebar because he's not going to be happy with how this is going. Dr. Rentschler has not even started yet. He's still a remaining witness. Now, jurors, I've got to ask you those same three questions. Are you as tired as I am of the defense wasting your time? Everyone nodded or said yes. Are you finding that all the defense team, their voices grate on your ears and cause you consternation? Everyone nodded or said yes. And you all agree with me that the Commonwealth is right in this case, yes? And everyone nodded. All right, defense, go ahead. I know I'm being a little snarky. I'm sorry. I need to dial it back a little bit. Oh, man. Josh says, that's why I put 10 memberships on the line. I knew she wasn't going to allow it. Thank you, Josh. I'm a little frustrated. I don't want everything. Let me give you an example. If I can talk fast. Over the weekend, I watched like a World Series of Poker.
You are unmuted.
Where the final hand, one guy won almost every single hand he was dealt for the last, 40 hands. It was like a sun run, they call it. I don't want that in court. I'm not like my side has to win everything and that's yay. I want it to be fair. I want it to be fair for the defense and fair for the prosecution and fair for the victims. And I don't see it right now in this trial. I don't see it being fair. It's one, the sun shines on one party and not on the other. And the judge is the clouds. So, there you go.
Hey. All persons have any business before the Honorable Beverly Kennedy, Justice of the Norfolk Superior Court, before the County of Norfolk. Draw near, give your attendance, and you shall be heard. I say the Commonwealth of Massachusetts. The court is now open. You may be seated.
Good morning, jurors. Thank you for your patience this morning. I know we brought you in late. Maybe should have brought you in a little bit later, but we've been working in an effort to sort of streamline things for you. So I do have those questions I have to ask you. Is everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or should. All right, can we have Dr. Laposada back, please? Yeah.
Doctor, I'll remind you you're still under oath. Thank you.
Thank you. I will.
Good morning, Doctor.
Morning, Your Honor.
All right, Mr. Jackson, go right ahead.
Thank you, Your Honor. Good morning, Dr. Laposada. Nice to see you again.
Good morning. Glad to be here.
Yesterday, when we last left off, we were talking about a small injury to the upper eyelid of Mr. O'Keefe. Do you recall that?
I do.
Could we have Exhibit 165 with the court's permission, please?
Okay.
I'd like you to take a look at a specific area. If I could. There we go. Right here on this exhibit. You see that area?
Yes, I do.
Tell us what that is.
And that is a horizontal splitting of the skin, which was caused by application of force that overcame the tissue's resistance, so the tissue split. And behind that, we see the raccoon-eyed discoloration of the eyelid from the basilar skull fractures.
Could we have Exhibit 13, please? I want to draw your attention to this area of the vehicle. First of all, do you recognize this photograph?
Yes, I do.
How do you recognize that photograph?
I recognize it from looking at it in my materials reviewed, that it's the rear of Miss Reed's SUV.
Taking a look at the area that I'm highlighting, right about there.
Yes.
Could we zoom in on that area? Do you see that overhang over the window?
Yes, I do.
If I use the word spoiler, would you understand what I'm talking about? If we call that a
Yes,
spoiler?
yes, I do.
Thank you, Katie. Thank you.
Is the laceration to Mr. O'Keefe's upper eyelid that we just looked at, is that consistent in your opinion with a strike from that area of the vehicle if that vehicle were traveling in reverse at, say, 20 plus miles per hour?
No, that rounded, thick area would not cause that skin defect in his upper eyelid.
If, in fact, a person were hit at, say, 20 plus miles an hour in the face with that rounded edge, what kind of injury would you expect to see on that person's face?
I would expect to see a ribbon of bruise that would correspond to the height of that spoiler, and then it would go across the eyeball, it would hit the nose. So I would expect to see some horizontal ribbon of bruise.
Did you see anything consistent with that, with Mr. O'Keefe's injuries?
No, nothing.
Thank you. We can take that down. We talked yesterday about this phenomenon known as coup contra coup injury to the brain, correct?
Yes.
What happens to the brain after a coup contra coup, a significant coup contra coup injury?
Yes, this was quite a severe brain injury. Was injured on the back of the brain and also the front of the brain. The falling back and impacting the back of the head made the skull fracture radiate along the base of the brain on the right and left sides. It also radiated around on the side of the skull, and that indicates a tremendous transfer of force and energy to the skull and then to the brain, and the brain is rattled around, therefore, within the cerebral spinal fluid in the skull. So what that does is that it breaks the connections between the neurons in the brain and causes small little hemorrhages, and it causes the brain to swell. So when you get an injury, like if you get an injury on your arm, it starts to swell. The same thing happens when that injury energy is applied to the brain. The brain starts to swell. And unfortunately, the brain, when it swells, it doesn't have anywhere to go because it's encased in the skull. So what happens is that the brain and the brain stem under the brain starts to go down the opening in the base of the skull where your spinal cord goes. And that is a harbinger of death, because that means that the brain stem is getting pushed down in this hole in the skull and compressing the areas in the brain stem which control the heartbeat and breathing. And that's called brainstem herniation. and that you just die after that. So that's what happened to Mr. O'Keefe's brain.
Your Honor, I have a document that I'd like to approach with.
Okay.
Is that a band name? Harbinger of Death?
Yes.
Doctor, can you take a look at that document that I've just handed you and tell me if you recognize it?
Yes, I recognize this.
How do you recognize that document?
From looking at the autopsy photos of Mr. O'Keefe's brain.
And what portion of the brain are you looking at?
This shows a photograph looking up under the brain, and it shows a cross section of the brainstem that went down in the hole in the base of the skull, and we see there's hemorrhage in it, and those have a special name. They're called Duret hemorrhages.
How do you spell that?
D-U-R-E-T with there's a little accent somewhere there.
Caret over the E?
Yes. And this shows that the brainstem is going down into the hole where the spinal cord goes. It's stretching the blood vessels and causes little hemorrhage and compresses the neurons in the brainstem, which control your heart rate and your respiration. It's called brainstem herniation, and that's a harbinger of immediate death.
Your Honor, with that, I would ask for the admission of that document is next in order, subject to the appropriate redactions.
Okay. So we'll take that into evidence. Yes.
Your Honor, with the court's permission, with the redaction, may I present the...
Not yet. 1 minute. Jurors, I told you before that there were photographs that have been introduced into evidence that aren't pleasant. And you may find that these photographs are graphic. And I'm instructing you again that your verdict must not in any way be influenced by the fact that these photographs, you'll see some more today, I believe, that have already been introduced into evidence. So your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant's entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by the photographs. Importantly, consider the photographs only as they may draw your attention to a clinical medical status or to the nature of Mr. O'Keefe's injuries themselves. So again, these will be presented to you in the deliberation room in an envelope. But today you'll see some on the screen, and I just wanted you to know that before you see it. So now you can display it.
Your Honor, may I approach very briefly?
Yes.
If you wouldn't mind taking a look at that document.
Oh,
is that
yes.
a redacted version or a closer-up version of just the brainstem?
Yes, this photograph shows the cross-section going this way of the brainstem with the hemorrhages caused by the brainstem going down into the foramen magnum.
With that, Your Honor, actually, I think with the court's permission, I would trade that as the next in order rather than the unredacted version.
All right, is there any objection to switching the exhibits like that?
No.
Okay.
Thank you.
Oh, and the arrows point to that on there.
So this is going to be the next exhibit?
That'll be it.
Exhibit 225, Mark.
Thank you.
The
other one will be for identification, the first one.
Thank you, Your Honor.
And that'll be FFF for ID. Number F.
Okay, you can display it now.
Thank you, Your Honor. Mr. Walt? Do you see what's displayed on the screen above your head?
Yes.
What is that?
Excuse me, that's a cross-section across the brainstem of Mr. O'Keefe, and it shows where the blue arrows I've put in there show the red areas, which are areas of bleeding, which is the sign of brainstem herniation. All the background is white material, and that's part of the appearance of neurons in the brain. So that shows that the brainstem, because of the brain swelling, pushed it down into the hole in the base of the skull where the spinal cord goes, and it pulls on the blood vessels, causing the blood vessels to break and the blood vessels to bleed, and that shows you that the brainstem has been compressed and damaged, causing death.
May I approach?
Yes.
I'm holding a green laser pointer.
Oh, thank
you.
you.
Use the display to your right, so the viewers can better see it. Could you point to the areas with that laser pointer of the bleeding that you indicated causes the swelling?
Okay, so, okay. Is that going on the...
It is. It's probably hard for you to see.
Oh, that's okay. So this sort of roundish thing is the brainstem, and the arrows are pointing to the red areas. So there's a blood vessel that's broken there because it's been torn and pulled, with surrounding blood going into the neuronal tissue here and over here and over here. And also some of this is also bleeding, with the blood looking brown because the brain was placed in formaldehyde. So all this brown area, the red area, should not be there.
Is this type of herniation life-threatening?
It causes death. Yes, it is life-threatening.
How quickly, we can take that down. How quickly, doctor, would you expect that this could cause, let's first talk about incapacitation.
Yes.
How quickly would someone be incapacitated after they suffer a coup contra coup injury of this magnitude with the concomitant injuries that you see in the brainstem?
Well, there would be two parts to what that injury would cause the body to do. First, there would be immediate unconsciousness because of the transfer of all the energy to the brain and the massive skull fractures. So that, excuse me, so that would disrupt the normal function of the brain and produce immediate unconsciousness. Then the brain would start to swell, and within 15-20 minutes or so, then that brainstem starts to go down the opening in the bottom of the skull, and then the blood vessels are broken, the brainstem gets compressed, and the centers in that brainstem which control the heart and the respiration then stop. So you go unconscious, brain swells, then you die.
Turning to the actual, your review of the actual brain, in this instance, Mr. O'Keefe's injuries specifically, did you reach any conclusion or opinion to a reasonable degree of medical certainty about his incapacitation, the length of time it would take for him to become first incapacitated and ultimately to be rendered dead?
He would be immediately incapacitated with a decreased level of consciousness. Once he received that impact on the back of the head, he would not be able to make any purposeful movements. There might be some arm jerking or some seizure activity, but he would not be able to carry. He wouldn't be able to get up. He wouldn't be able to walk. He wouldn't be able to do any purposeful activity. He would be severely concussed, unconscious, not able to walk, not able to carry out purposeful activity. And then as the brain continues swelling and that brain stem gets compressed, then the heartbeat is disrupted, the breathing is disrupted, and then those heart and breathing stop. And within 15 or 20 minutes, then he could be dead.
Is that opinion to a reasonable degree of medical certainty?
Yes, it is.
You testified concerning wound pattern recognition pretty extensively during the course of your giving your qualifications. What is a patterned injury?
A patterned injury is very basic to the training in forensic pathology and medicine because it helps us understand some change on the body, some pattern injury that corresponds to the object that made it. So we can look at an injury and say, we can figure out what made that. Sometimes you can, sometimes you can't. But a pattern injury is very important for a forensic pathologist to recognize because it's going to really help the police investigation, because I can say, oh, this looks like it's a wound from scissors. This looks like it's a wound from a screwdriver stab. So by identifying the pattern that object makes on the body, I can help the death investigation by helping the police say, look for some screwdriver, look for some hammer. So looking at that, identifying a pattern injury is really important it's basic to the forensic pathologist's knowledge base, and then also very important to the investigation of the crime or incident.
I'd like you to look at another photograph, an exhibit that's already been put into evidence. 160, please, with the court's permission.
Yes, jurors, this may be one of the photographs as well. Right. Or there'll be a series.
Dr. LaPosada, I want to draw your attention to the center of this photograph.
Yes.
First of all, do you recognize what's depicted here?
Yes, I do.
How do you recognize?
I recognize it from reviewing the autopsy photographs of Mr. O'Keefe.
You reviewed it, informing your opinions and conclusions?
Yes.
Can you describe what's depicted in this photograph? What are we looking at?
Yes. So we're looking at the back of Mr. O'Keefe's head and an injury caused by the angular acceleration going down and hitting his head in the back. And then this is also a patterned injury. So what we see is the horizontal tear of the scalp, and we can see it's undermined a little bit. So that means the direction is going from bottom to top. Also, we see these sort of vertical lines in here and down below. So what that tells me is that the back of his head hit something that had a fine granular pattern to it to cause those individual little marks, and then also something that had a linear or ridged pattern that he went back on that broke the scalp there. So we have two parts really to this pattern injury. We have the horizontal tear of the scalp made by impact with some sort of ridged surface. And then we have these vertical scraping of the skin above and also below. They're obscured a little bit by the ruler there, which says that whatever he hit had some little like granularity to it, with each little sort of granule making those vertical marks, and then the ridged pattern having the major point of impact.
What is the significance of the pattern when you say ridged pattern? And there's two things we're looking at: the laceration or the abrasion versus the defect above and below that laceration.
Yeah. So what this injury tells me, or what I would tell the investigators, is that Mr. O'Keefe went back onto some object that had some sort of ridge to it to make that horizontal tear in the skin, but that ridge also it wasn't smooth. It had some little grainy grainy things sticking up on it that would make each of these little things. And then it's the job of the police then to go back to the scene and look around for something which might fit that pattern.
We can take that down. Did you, in furtherance of your investigation, coming to your opinions and conclusions, look at the area of 34 Fairview?
The outside, yes.
Meaning photographs?
Yes.
Did you also see photographs of any significance to you related to the garage, the interior of the garage?
Sustained. Jurors, disregard that comment, that question.
What part of the area did you see? What part of the location did you see?
Excuse me. I saw all the scene photographs taken by the police, which showed the front yard in the area where Mr. O'Keefe was found. I also saw some photographs of the inside of the house and the inside of...
So I'm going to stop you there, Dr. Lapasada. Jurors, I'm striking anything after what the pictures from outside, Mr. Jackson. Move on.
Let's stay with the outside of the home. Did you see the front lawn area?
Yes, I did.
How did you? What did you note about the front lawn area?
Well, I was looking at the area where Mr. O'Keefe's body was found, because we know once he came back and slammed his head, he's not going to get up and move around.
So, yes, I'm going to strike the second part of that. Just answer the question specifically.
Okay, I'll try, Your Honor. Thank you.
Why were you interested in the outside area where his body was found?
Because then I could identify an object possibly there that would have caused the injury on the back of his head.
Did you see any such object in any of the photos that you reviewed?
No, there was nothing. There was a flat grass surface.
Would the flat grass, let's assume that the grass was very cold and very hard, the dirt was very cold and very hard. Would falling backward onto that dirt, hard or not, would that cause the patterned injury that you see, that we just saw in Exhibit 160?
No.
Why do you say that?
Because if you fall back on a flat surface, you get many times the tear you get in the scalp can be more like a star, because you've just hit one part and then the tears go in kind of a star pattern. And also because you would not have those discrete vertical scraping of the skin. You would tend to, if you fell back on grass, you would tend to see, you might see grass in the wound, or you would tend to see an irregular kind of crisscross pattern of the flattened grass. And that's not what we have here on Mr. O'Keefe.
Do you have any training or experience in diagnosing hypothermia in individuals?
Oh, yes.
Have you conducted autopsies of individuals who have suffered from or died from hypothermia?
Yes, many.
How many?
100 or more, and then I've supervised my assistants who've also diagnosed the same death from decrease in body temperature.
Have you ever engaged in any death investigation, aside from the actual autopsies, death investigations in which the cause of death was deemed to be hypothermia?
Yes.
How many times would you say you've undertaken that type of investigation?
At least 100.
Have you ever reviewed any peer-reviewed medical literature associated with or discussing hypothermia and something known as Wisniewski spots?
Yes, that's in the medical literature and also in our forensic textbooks.
Did you review the medical examiner's file, Dr. Scortibello's file, as it related to, in connection with this case? You reviewed the entire file, correct?
I did.
Did you conduct a differential diagnosis as it relates to the potential for hypothermia?
Yes, I did.
Describe, before we get into your findings or your conclusions and opinions, what is inferential thinking?
Inferential thinking is another name for making a differential diagnosis. In other words, seeing a finding and then saying, how many ways can I get that finding? And then go and investigate each one of those ways and either rule them in or rule them out as being responsible to causing that finding.
Did you note whether or not the medical examiner, Dr. Scortibello, mentioned hypothermia as a potential cause of death in this case?
She did put that on the death certificate.
Along with something else?
Along with the blunt force head injury.
Do you agree with or concur with the blunt force head injury as a cause of death?
Yes, Mr. O'Keefe died from the blunt force head injury.
Do you concur with the diagnosis of hypothermia?
No, the body did not have any hypothermia.
What led you to that conclusion?
Well, when you have we know that normal body temperature is around 98, and we know that then at the hospital that Mr. O'Keefe's rectal temperature was around 80. So we know that his temperature went down. So there are two ways the body temperature can get down. It can get down while you're alive, or a dead body also cools when it's in a cold environment. So those are the two things you have to look at.
I'd like you to take a look.
Show Mr. Yep, show Mr. Warrington.
I think they need to do a better job of explaining the symptoms of hypothermia.
Do you recognize what's depicted in that photograph?
Yes, I do.
What is that?
This is a photograph I took from our forensic medical literature, and it shows the lining of the stomach. So the stomach is opened up, and we look at the lining of the stomach, and it shows a characteristic pattern of small ulcerations throughout the stomach, which are called medically Wisniewski's ulcers. And that allows a forensic pathologist to diagnose death from being exposed to a cold environment or death due to hypothermia. And they're caused by, as the body gets colder and colder when it's alive, the small blood vessels in the lining of the stomach, they start to break, and then they're in the acidic environment of the stomach, and you get tiny little ulcers, which then look like small dots. And that is how at postmortem examination or autopsy, it's one of the findings I look for to see if a person died from hypothermia.
Doctor, what is gastric mucosa as it relates to the stomach lining?
The gastric mucosa, when you open up the stomach and you look at the inside, the first cells lining that inside is called the mucosa.
Is that what we're looking at in this photograph or no?
Yes, we're looking at the mucosa with ulcerations, which are little craters that form in it due to hypothermia.
Is that exemplar of what Wisniewski spots looks like as it relates to hypothermia from a book that is, or literature that is peer-reviewed?
Oh, yes.
Is it widely accepted in the medical field?
Yes, it is.
And is it referenced by forensic pathologists and used in teaching?
Yes.
Your Honor, I would move for the admission of that photograph.
Okay.
Exhibit 226.
Permission to display, Your Honor?
Yes.
Is this a fair representation of what you were just looking at?
Yes.
Describe what we're looking at.
Okay, so this, I took this photograph from our forensic medical literature, and this was from a person who died due to exposure to a cold environment. And this is the stomach has been opened, and we're looking at the inside of the stomach. And the normal appearance is kind of pinky white. That's how it should look like. And what's abnormal here is all these black dots, which are the Wisniewski's ulcers, which are diagnostic of death due to exposure to the cold. So these areas are little tiny craters, and they fill up with blood. And we see that in over 90% of the cases of people who die from exposure to the cold.
Doctor, did you also look at Mr. O'Keefe's stomach lining?
Yes, I did.
If we could have, with the court's permission, Exhibit 164 put up as well.
Okay.
Do you see the photograph on the right?
Yes.
What is that of?
This is the Mr. O'Keefe's stomach, which has been opened up, and we're looking at the inside. We see that the mucosa is a little bit red, and there's a little bit of increased blood flow here. And this is the normal pattern of the inside of the stomach. It's kind of ridged. that's called rugae. That's the normal folds inside the stomach. But there's no ulcerations here. So the diagnosis of death due to hypothermia is not appropriate in his case.
Did you see, or do you see, any classic Wisniewski spots in Mr. O'Keefe's stomach lining or gastric mucosa?
No.
Do you observe any ulcers specific to Mr. O'Keefe's stomach lining?
No, there are no ulcers. It's a normal appearance of what we would call a gross specimen. When you open the stomach at autopsy, you can see some redness of the normal lining of the stomach.
Let me ask this first. Do you have an opinion as to a reasonable degree of scientific certainty based on the totality of your review and examination of the autopsy and its associated file, an opinion as to whether or not Mr. O'Keefe died of hypothermia or complications related to hypothermia?
I do have an opinion.
And what is that opinion?
He did not die of hypothermia.
And is that opinion to a reasonable degree of medical certainty?
Yes.
Taking a look at the darker red areas in the stomach lining of Mr. O'Keefe on the photograph to the right.
Yes.
That's Exhibit 164. Can you describe what those are? What are those darker areas?
Here we see a little bit of bleeding. The darker areas are the areas of the lining that are at the bottom of the normal rugae, because the inside surface of the stomach sort of looks like it's covered with little mountains. And so we can get the redness in between what the rugae in the stomach. And there's a little bit of increased redness here, but no ulceration.
Do you have an opinion, or were you able to form an opinion as to what the increased redness might be or is associated with?
Yes.
Did you note anything of significance in the rest of your examination of the file, the autopsy file, the medical examiner's file, that was related to what you see in the photograph 164?
Yes.
All right, I'm going to see its sidebar for just a minute here.
Can you take that down?
First sidebar. Sorry, jurors. Jurors. You may have noticed that during the last testimony, I've been working on some paperwork up on the desk. That is in an effort to speed things up, to not waste your time. I've just been filling out the verdict sheets for you, and hopefully that will just save some time at the end of the trial. Thank you. Quick sidebar. I'm sorry. I need to reset. That was quick. She was not allowed to talk about the inside pictures of the garage because those pictures were ruled inadmissible. The pictures didn't come in, so she can't talk about having looked at them.
May I continue?
Yes.
Thank you. With regard to the, it's my word, not yours, doctor, so forgive me, the defects, the redder marks that you're mentioning on the rugae or in and around the rugae on the gastric mucosa, did you note that there was a machine that was used for life-saving measures as it related to Mr. O'Keefe?
Oh, yes, it caused some damage to the body.
Okay, let's talk about that for just a quick second. What is that machine called?
It's a mechanical device to administer chest compressions, and the company that makes it is called Lucas, or one of the companies, so it's called a Lucas machine, and it can be attached to the body. Your arms go up over a ridge, and there's a plunger, and it goes around your back, and so it just plunges, and it does mechanical resuscitation and chest compression, compressing the chest right over the lower sternum, about 2 inches or so, and it's very helpful in a situation where the manual compressions, where the attendants and the ERT people, they get tired continually compressing for a long period of time. So the mechanical device was invented to prevent the EMT fatigue when administering chest compressions.
When you mention the sternum area of the body, are there, you go without saying, are there organs beneath the area that's being compressed by the mechanical Lucas machine?
Oh, absolutely.
What do those organs include?
Well, ideally they include the heart because that's what's supposed to be pumping the blood out, but it's also in a circular area that's right below the sternum, which includes the heart. But what is also under there is the esophagus and the interior of the stomach. So this area is right under where the machine is compressing as well, as long as, in addition to part of the head of the pancreas, which is also right there under the lower sternum. And what can happen with the Lucas machine pushing in for 100 times a minute for a depth of about 2 or 2.5 inches, that these organs right underneath of it get compressed between the Lucas pump and the bony vertebral bodies that's along your back. So you have the Lucas machine compressing these organs, and they're compressing them against the vertebral bodies of your bony vertebral column in the back. So you can get other injuries, organ injuries, that is a complication of the automated mechanical resuscitation. You can get cardiac ruptures, you can get ruptures of the liver, because all those organs are clustered right there, and that machine is pushing those organs in between the pump and the back of the bony spinal column.
Doctor, in your review of the medical records, was there any indication that an automated chest compression machine, a Lucas machine, was used on Mr. O'Keefe?
Yes.
May we can take this down?
Yes.
Those machines are vicious. They're very effective at what they do, but the goal is to keep you alive, not to not cause pain or damage. And CPR can be exhausting even for short periods of time.
There's 2 documents that I'd like to show you. First,
yes,
that document, and then after you're finished, familiarizing yourself. First one and the second one.
Yes.
Taking the first document that addresses the Lucas machine,
yes,
how do you recognize that photo or those series of photos and graphs?
These are illustrations I put in my report, and one shows a generic patient with the Lucas machine in place around him to do the chest compressions. Then I have a photograph of the actual apparatus of the Lucas machine itself. Then I show what's recognized as medical complications and injury from that machine. It shows, I have an example of a CAT scan of a section through the body horizontally, right where the plunger goes into the chest. And it shows in another patient hemorrhage around the pancreas and around the top of the stomach. Then I have a diagram also taken from our medical literature that shows the direction of force that compresses those organs between the resuscitation paddle and the vertebral body and the backbone.
Doctor, are those photographs and graphs taken from peer-reviewed literature in the medical field that's normally relied on by other medical professionals?
Yes.
Your Honor, I'd move for the admission of that first document.
Right. Subject to redaction?
I don't think so. I think that that one is not objected to.
Okay. All right. So would you hand that to...
Sure, thank you.
It's just like subject to redaction. No, it's a medical journal.
Exhibit 227.
Permission to display, Your Honor?
Yes.
Doctor, I know that's a little bit small and far away. We'll enlarge it as you need. It's not an eye test. Can you tell me what we're looking at? Yeah, let's take the top half of the document. What is that to the left, and then what's the machine in the middle.
Okay, so what you see on the left is a anonymous patient showing how the Lucas machine is placed onto the patient, where the arms are pulled up and clasped against these rigid mechanical bridges, and then here is the engine which puts the pump, and that's the pump which just goes up and down to do the chest compressions. And so that's how it's affixed to a patient.
To be clear, doctor, that is not Mr. O'Keefe. That is
No, this is
could be a model.
an unknown person.
Okay. And then what are we looking at in terms of the actual machine to the
Yeah,
right?
this shows the actual machine before it's put on a patient. You can see how it encircles the patient, and then there is this circular pump, which is the compressor pump.
If we can look at what is that a picture of, the highlighted portion?
That's the circular part that actually is projected down onto the body.
That makes contact with the chest?
Correct, and it has a spring in there that the engine above it gives a certain number of compressions per minute.
And you said on average the compressions per minute would be about what?
They should be around 100.
Okay. If we could go to the bottom half
pinch
of the page.
point. Do not stick fingers here.
What are we looking at in this photograph?
Okay, we're looking at, on the left side, we're looking at a CAT scan, which scans a person who's had some injury from the Lucas compression machine, and it's a cross section. So the arrow here is pointing to the head of the pancreas and the area of the esophagus, and then the machine would compress down onto that. And the important part is that I don't know if that's working on there. The little thing that looks like at the very bottom, that's circular and then has a little, looks like a little steer head, that's the vertebral column, and that's bone. And so the pump is pushing in that area where the arrow is pushing those organs against the bony vertebral column. Excuse me. And that's on an actual patient that had that. Then on the right, it shows the schematic of the blue arrows indicating the force coming down. Then we see the organs, and the red arrows show how the pancreas can get hemorrhage, and also some of the esophagus that goes into the top part of the stomach. And we see that's, I can't really see where that, I think it stopped.
Oh. May I approach you?
Yes.
No, it's just green on bright white.
Oh, no, you've got it. Okay.
Give you a pattern issue.
Okay. And then we see at the bottom with those three little things projecting from it, that is the vertebral body, which is made up of bone. So you can see how the chest compressions, not only hoping to save the life by keeping the heart blood functioning, can also cause some injuries and damage, not life-threatening usually, to the other organs there.
We can take that down. Doctor, taking a look at the second document that's in front of you, do you recognize what's depicted in that document?
Yes.
What is that?
This is a picture of Mr. O'Keefe, his chest, while he's at the hospital, which shows a lot of the resuscitation equipment.
Is that a true and accurate depiction of of Mr. O'Keefe at the hospital based on your review of the medical file?
Yes.
I'd move for the admission of that.
Okay.
Oh.
Exhibit 228. Then.
Permission to display briefly.
Okay.
Taking a look at the photographs to the left and to the right, do you see any indication on Mr. O'Keefe's body that is suggestive that where the Lucas machine was situated?
Yes, as I pointed out here with the blue arrows, that big circular mark there is the mark on the skin where the compression pump compressed the chest of Mr. O'Keefe, and it caused some rib fractures, and it also caused those reddening of the stomach and some hemorrhage in the pancreas.
We can take that down. Doctor, based on your review of the medical records, did you calculate the approximate number of compressions that Mr. O'Keefe would have been subject to based on that Lucas machine?
Yes.
What is that calculation?
His body was found around 6 in the morning, and he got to the hospital around 6:37, I think. So if they put the Lucas machine on him when they got him into the ambulance, and it's compressing at 100 times a minute, and that is from the time of the body being discovered to the time at the hospital, that's around 37 minutes. So if you multiply 37 minutes times 100 compressions a minute, that's around over 30,000 compressions that would have been done to Mr. O'Keefe's body in the course of his resuscitation efforts.
Doctor, do you have an opinion as to what caused the hemorrhaging that we saw on Mr. O'Keefe's stomach lining?
Yes.
What is that opinion?
It was from the blunt compression of the Lucas machine.
Is that opinion to a reasonable degree of scientific certainty?
Yes.
You indicated earlier that there is a difference between someone dying of hypothermia or complications associated with hypothermia and a body that's already passed away just cooling, correct?
Correct.
Do you have an opinion as to a reasonable degree of medical certainty as to whether Mr. O'Keefe suffered from hypothermia?
I do have an opinion.
What is that opinion?
He did not experience hypothermia.
Did you observe any signs of frostbite?
No.
Did that have any weight concerning your opinion, overall opinion, as to whether or not Mr. O'Keefe died with complications associated with hypothermia?
Well, if someone dies due to exposure to low temperatures, you expect to see not only the Wisniewski's ulcers, but you expect to see some frostbite changes in the extremities.
Based on your overall review of the medical records associated with Mr. O'Keefe, were you able to reach an opinion and conclusion as to the cause of death of Mr. O'Keefe?
Yes.
What is that opinion?
He died of brain injuries and skull fractures due to blunt force trauma of the head.
Do you hold that opinion for Mr. O'Keefe's cause of death to a reasonable degree of medical certainty?
Yes.
I want to shift gears for a minute, Dr. La Posada, and talk about patterned injuries elsewhere on Mr. O'Keefe's body. You've obviously talked about your training and experience as it relates to recognition of patterned wounds, correct?
Correct.
That's something that you were trained in when you were training, correct?
Yes, it's very basic to the discipline of forensic pathology.
And have you also trained others during the course of your 40-year career on the issue of wound pattern recognition?
Yes.
You've taught courses and given lectures, is that right?
Yes, I have.
It's laying the foundation.
I'd like to show you Exhibit 167 with the court's permission.
Okay.
Just to show Mr. Brennan, see if there's an objection here.
Do you recognize what's depicted in this photograph?
Yes.
How do you recognize it?
Is a photograph of the right arm of Mr. O'Keefe.
Did you review and consider this photograph and others in coming or forming your opinions, coming to your conclusions and opinions in this case?
Yes.
He has to ask a leading question here, so she doesn't say dog bite.
In order to come to your ultimate opinion and conclusion, or opinions and conclusions in this case, is it important to take all of the injuries that a decedent may have suffered into account rather than one or two piecemeal?
Now you have to look at the whole picture to understand what happened to the body.
Why is that? What's the importance of that? It may be obvious, but explain that for the jurors, please.
Well, when you're looking at changes and injuries to the body and trying to understand what happened to the body, there are different patterns of injuries on different parts of the body. And by trying to separate those and understand what patterns were caused by certain things, then you're able to put together a sequence of events that happened to the body prior to death.
What role do photographs play in a forensic medical examiner reviewing the medical evidence and coming to opinions and conclusions? How important are photographs?
Oh, those are huge. It's standard practice to always document at the postmortem examination important findings with photography.
Were the photos in Mr. O'Keefe's case useful in coming to opinions and conclusions concerning his injuries altogether?
Yes.
What about the injuries to his right arm?
Yes, those photographs are very important to understand those injuries.
Do you believe that there is a patterned injury on Mr. O'Keefe's right arm?
Yes, there is a pattern injury there.
Have you ever seen, in your experience, either being taught or teaching, patterned injuries as they relate to animal wounds, generally?
Oh, absolutely. Very common.
Do animal wounds include both claws and teeth, dentin?
Yes.
So bite marks and claw marks might be two different types of patterned wounds that you may see in your evaluation, just
Correct.
in general?
Correct, because when an animal approaches the body, there may be damage from the claws and also from the mouth.
Do you expect to see punctate wounds as well as linear abrasions?
Yes.
Do you expect to see certain bite patterns as well?
Yes.
What types of injuries, let's talk about animals in general, what types of injuries do animals produce on the skin of human beings?
Well, animals can produce, if you're talking about, mammals, they can produce injuries from their claws, where you get parallel scrapes of the skin from the claws applied to the skin, or you could see a pattern from the jaw configuration of the animal. And most animals that attack or get in contact with the body have canines. So there's two canines on either side that make paired marks, and that would be called a pattern injury. So it makes parallel sort of gouges, and as the canines move in a horizontal pattern or a vertical pattern, the space between them can change. The other thing you see in a animal bite is you see not only the canines that come out, but depending on how the jaw is applied to the body, you can have little dot-like imprints in sort of a U-shaped pattern, which are from the incisors, the little incisors of the animal. So you look for punctures, you look for paired gouges, which would be the canines, and then you look for arced patterns of little dots, which can be the application of the incisors of an animal bite.
What is an incised wound?
An incised wound is a wound due to cutting from a sharp object.
Would you expect to see incised wounds from an animal bite or claw marks?
No, they don't cause, they're not like knife wounds. They cause more of a scraping injury.
Do you see the injuries that you're looking at in Exhibit 167, are these more consistent with incised wounds or the scraping abrasions that you just talked about?
Sustained.
Were you able to determine from your review of the medical records whether the injuries that you see on Mr. O'Keefe's right arm were pre-mortem or post-mortem?
They were, oh yes, I can determine that. They were inflicted prior to death.
Do you have an opinion as to whether or not the wounds that you see, the patterned injury that you see on Mr. O'Keefe's right arm, is consistent with an animal bite or claw marks?
Yes, it is, very much.
Thank you. We can take that down.
Is that opinion to reasonable degree of medical certainty?
May I have just a moment, Your Honor? Actually, Your Honor, may we approach very briefly?
Okay.
Sidebar number 2. I think that is the limit of what he's allowed to go into with this witness. That is the split in the baby result that he fought for and won over the Commonwealth's objections. Everyone's going up to sidebar. John O'Keefe's mom left during the showing of the Lucas device on the anonymous patient and has not returned yet. That's her seat there. The benches are rather hard. She brings a cushion. I do not blame them. Rodney, as far as the jurors and reactions, Sue O'Connell on Twitter, who is affiliated as a commentator with NBC 10 in Boston, is keeping a running record of everything happening in the courtroom. Let's see what her latest is here.
May I inquire?
Yes.
You indicated that, in your opinion, the wounds to Mr. O'Keefe's arms were pre-mortem, not post-mortem. His right arm, I should say, were pre-mortem, not post-mortem, correct?
Correct.
What's the basis for that opinion?
Well, a forensic pathologist has to be able to differentiate changes that happen to the body while the person is alive versus things that happen after the person is dead. For instance, there is something called post-mortem predation, where if the body is out in the woods and dead, then wolves and such can come and make, quote, injuries to the body. But we're able to tell from our training and experience that those were made after death. The usual way we tell is that when it's made during life, the blood vessels that are damaged, the heart's pumping blood through, so you can see a reddish color and maybe some blood around it. Whereas if the body is damaged after death, the changes to that body and those, quote, injuries look more yellowish and kind of brown because the blood is not flowing. So that's how you can tell if something done to the body is while the body was alive or whether it was done after death.
Do you have an opinion to a reasonable degree of medical certainty that the wounds on Mr. O'Keefe's right arm were pre-mortem?
Yes, they were done while he was alive and bleeding.
You talked about death investigations. As a matter of fact, you mentioned something about what a forensic pathologist's role is in a death investigation to potentially send investigators back out to answer certain questions, correct?
Yes.
Did you see any evidence in the medical records or the medical examiner's complete records that any effort was made to send investigators to the location to see if there were any animals at the location at or around the time of John O'Keefe's death?
Sustained.
Do you believe it's important? Well, let me ask it a different way. Would following up with investigators be an important part of any forensic pathology investigation?
Oh, absolutely. You're working as a team to figure out what happened to the body.
Thank you. we talked about the theme and theory of differential diagnosis, correct?
Yes.
How does engaging in the process of differential diagnoses avoid bias in an investigation?
By after you have your findings and you sit back and think, well, how many ways could I get this finding? And so bias sometimes means, oh, I think it's this, and then you just stop. So that's a sort of a bias where you make a decision too quickly and you don't then stop to consider what other things could cause this same finding. So you have to consider not only what immediately comes to mind, but then you think, how else could we get this pattern of injuries?
Did you engage in a differential diagnosis as it relates to this case?
Yes.
Did you consider whether the injuries could have been caused by a motor vehicle accident?
I did consider that.
Did you consider whether Mr. O'Keefe's right arm injuries specifically could have been caused by being hit by a motor vehicle?
Yes, I did think about that.
Were you able to rule that out?
Absolutely.
So the objection sustained, jurors strike that answer.
Tell me about, well, let me ask it this way. Did you come to an opinion or conclusion as to whether or not Mr. O'Keefe's injuries as a whole were produced by a motor vehicle pedestrian incident?
Sustained.
You indicated that you've done thousands of autopsies yourself, correct?
Yes.
You've supervised many times more than that.
Correct.
How many of those autopsies that you've performed or supervised have involved motor vehicle incidents?
Now, hundreds.
How many of those hundreds have involved motor vehicle pedestrian incidents?
Almost as many.
Have you performed autopsies specifically on individuals known to be hit by vehicles?
Yes.
Have you performed autopsies on individuals believed to be hit by vehicles?
Yes.
Have you engaged in differential diagnosis and inferential thinking in terms of developing an opinion or conclusion to a medical certainty about whether or not the injuries that you see on a decedent are consistent or inconsistent with a motor vehicle pedestrian incident?
Yes, that's part of what we figure out as a forensic pathologist.
Did you do that in this case?
Yes, I
Sustained.
What are some of the injuries that you would expect generally to exist if a pedestrian is hit by a motor vehicle at speed? Not 1-2 miles an hour, let's say 20 plus miles an hour.
Yes, one of the things you see is a pedestrian is, standing upright and is impacted by this blunt object of a automobile or a van or a SUV. And what you see first most is the tissue is crushed where the projections of the vehicle impact the tissue. And when you crush the tissue, that gives you a bruise. So that's the first part of the pattern of impact. It crushes the tissue, it gives you a bruise because it breaks the blood vessels underneath the skin. And then depending on how much more force is applied, the skin can break.
So I'm going to strike that. Next question, Mr. Jackson.
In addition to bruising, what else might you expect to find in an individual who's been struck by a vehicle at speed?
So let's come over to sidebars.
So our day of no sidebars has now had 3 sidebars. A jury might be wondering, why can't she answer these questions? But judge has her reasons. The scope of the testimony is limited to what she can give, and I think she's pretty much given everything they can get from her without objection. Love that she brought sample pics to compare with his autopsy so they can see if they do or don't match up. She does seem quite qualified to answer some of these questions, especially about the car crash, if it's consistent. Differential diagnosis. It was ruled out by the judge's ruling yesterday that she is not able to give that testimony. Even though in the argument this morning it was explained that she used the same procedure that Dr. Russell used, which allowed her to testify about it. So, we see. Trying to imagine what the cross-examination of this witness is going to look like by Mr. Brennan. I'm pretty sure he's going to be the one that does it, because he's the one objecting. That's usually what you see. She's a nice lady. She's got some years of experience, a lot of years of experience, and I don't think she's warranted an attack. No, so I think he has to limit his, or for most effectiveness, he should limit his cross-examination to those things that would question her conclusions or her process for examination. He's probably going to ask about those spots inside the body that are symptomatic of hypothermia, and how in 10% of the cases they don't occur. He's probably going to ask things like that. But I don't know. He might ask if they use Signal to talk to each other. Sidebar and chill. I agree. At this point in the trial, sorry, these goldfish are so good. I'm sorry to be eating here on camera, but thank you very much for the bags of goldfish. At this point in the trial, he is very mindful of where the jury is. There's not much more time to influence the jury to help them see something one way or another. So when Mr. Brennan speaks, he asks the question to the witness and looks at the jury. He gauges reaction with almost everything he says. He wants to know if it's landing, if it's sticking, if jurors are shaking their head or nodding or, confused. He's very much connected to where the jury is, and he's got to be paying attention. So if it starts not going his way, we might see some frustration. We might see a change of tactics even.
May I inquire?
Yes.
I forgot where I left off, so I'm just going to pick up.
Okay.
As best my memory can serve me. It has been suggested that Mr. O'Keefe's right arm, Doctor, was injured by contact with the right rear taillight of Miss Reed's 2021 Lexus LX570.
Objection. No, I'm allowing that in.
Thank you. As Mr. O'Keefe, it was struck as Mr. O'Keefe was standing and the Lexus backed into him. That was a postulate put forward. I want to find out from you, do you agree with that?
Well, that's something to think about.
So,
oh, I'm sorry.
Yes, I'm going to strike that question and answer.
Let me ask it a different way. Let me ask you a different question. Mm-hmm. Do Mr. O'Keefe's pattern injuries on his right arm, do they correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm?
No, not at all.
Why do you say that?
First of all, those injuries are patterned injuries from an animal bite. We have the canines, we have the incisors.
All right, so I'm going to strike that, and let's see you at sidebar.
She said animal bite. You can't gag the expert from saying what they think. So the judge allowed the first question, struck it on how he finished the question. He asked the question again. She allowed it. Struck it based on her answer. Oh, my goodness. Sidebar number 4. Jurors. We're not going to do any sidebars tomorrow. We'll just be proceeding as normal through everything. The frustrating part is the witness doesn't know what she can and can't say. So Mr. Jackson is doing his best to ask the question in a way that's allowed, and I think he mostly did. Yeah. Sidebar counted for the rest of the trial? No, just for today, because today's a no sidebar day. We're sidebarless. She could say animal. She could say they're consistent. She said they were caused by. She needs to say the injuries are consistent with an animal attack, but she can't say bite. You can't get into the whole teeth thing. Yeah, you can't use the bite thing. We're on sidebar number. Well, this is 4, right? We're counting today. Sidebar number 4. They're taking the bite out of her testimony, quite literally. Looking at the schedule here, it is 11 o'clock. I wonder if the jurors are going to be sent on break while we sort this one out. It is supposed to be a full day today. We're not as ahead of schedule as the judge let on yesterday. Mrs. R.A. is finding something funny. Yeah, no half-a-days. Dr. Russell couldn't say attack. I think the problem was she said they were caused by, like definitively, they were caused by an animal bite. You can't say bite. I think she needs to say they're not consistent with a tail, or she can't say tail light. They're not consistent with the irregular injuries that you'd expect to see from, broken polycarbonate, irregular plastic pieces. She can say that, and she could say that it is consistent with an animal attack, but she can't go much further than that. It's difficult to thread the needle with the questions, and it's even harder to get the witness to stay in those bounds as well. Can she say bit? No, can't say bit. I think Mrs. R.A. is watching the comedy sketch. We are hearing the jurors are frustrated. Mr. Brennan causing the objections or raising the objections might be viewed as the source of the frustration. Sue says one of the jurors was bent over with arms outstretched and almost hit a mic on the banister. They're super frustrated by their body language.
May I, Your Honor?
Yes.
In your report, Doctor, you indicated that Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. Do you recall putting that in your report?
Yes, I wrote that.
Do you stand by that?
Yes, that's my conclusion.
And you also wrote his arm had no tissue bruising from impact injury. Do you remember writing that?
Yes.
Do you stand by that?
I do.
You also wrote, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. Do you remember writing that?
I did.
And do you stand by that?
I do.
He's allowed to lead her through. So she
you
also
wrote that you noted Mr. O'Keefe had no bruising on his arms or torso. Is that right?
Correct.
And you also wrote, in particular, Mr. O'Keefe did not have bruises on his legs, correct?
Yes, correct.
And you indicated that that was shown by dissection of the leg tissue and muscle at autopsy. Is that right?
Yes, there was a special leg dissection done to look for bumper impacts.
Okay. You reviewed the entirety of the medical records associated with the autopsy,
Yes,
including photographs,
taken to the hospital, yes.
okay, and autopsy photographs,
Yes,
and other data and documentation, correct?
yes.
Are x-rays an important part of an autopsy generally?
Oh, yes, usually there are x-rays taken of the body prior to the examination.
What do x-rays show? Why are those important?
They're important because they show foreign material in the body, like a bullet. They also image the skeleton, so we can look for fractures of the bones.
What's the ASMR? Tape?
That may have different audio.
Okay.
I was going to guess that Mr. Jackson was... Holy cow. He brought the whole plan room with him. He's got the whole plan room. I was thinking he was opening his own goldfish, but no.
May I approach?
Okay.
Where was he hiding that? That's funny.
Yes.
Sidebar number 5. He's got like a whole roll, poster-size images. Massive ones. He shows Brennan immediately they want to approach. Has Brennan seen these before? Local poster shops had a windfall. Those x-rays are petty, and I love it. I wonder what he wants to redact from this. Why would they not be allowed in? If they're in the medical file, if they're in the entire medical record, they should be allowed in, I would think. This is the perfect witness to bring them in on. Redact the noise they make. He was objecting to the ASMR. Let's see. Had a class, did I miss anything important? Do I need to go back? As somebody else said, we had a fist fight. The judge tagged Brennan out and finished it off. And it was pretty spicy this morning. It wasn't a fist fight, though. We did get, I think the most daring comment that was made this morning so far was when the judge came back after listening to argument, made her ruling, and AJ stood up and said, "It's ridiculous." Whoa. Whoa. Tread carefully, my friend.
Recess.
Oh, everyone out to the jungle gym.
Please rise for the jury.
It's time for the recess. Outrageous. Yeah, it's outrageous. Not ridiculous, sorry. It's outrageous. Did I say ridiculous? Or redonkulous? Amber, this morning has been fire. It's been a crescendo. Let's put it that way. Court is reaching a crescendo. Judge now has the big
Dr.
paper.
Lapasada, you can step out. Okay. All right. I did receive another motion this morning for a curative instruction. I'm not going to even consider this today. We can consider this at the charge conference. So that's where we're at with that. All right. Work it out. If you can't work it out, let me know. I'll come out before the jury.
All rise for the court, please.
The judge is ticked. She's like, I said no sidebars. We've had 5. You guys fix this. Fix this. Learn how to play nicely with each other on the playground. Share the toys. Take turns. Or I'm going to solve this for you when I come out before the jury. The fact that they say work this out, the judge feels that this is something that can be worked out, that they should be able to come to an agreement on this. And I think that means that Mr. Brennan is probably in a strong position. Or excuse me, Mr. Jackson's probably in a strong position because the judge feels that, this should be a no-brainer. It's a filing, though. Can we read it soon? If it'll show up, we've been refreshing all morning waiting for this filing to pop up. Amber, if you've seen it. We're still on direct. Let's see, Amber, you've got... Amber's checking. We're looking for that filing from Mr. Alessi, the one that the judge says, I'm not even going to address this now. We're going to address it at the charge conference, which is basically at the end of trial, charging the jury, going over the jury instructions, and we'll also address this other part. I think she's more mad about that than anything else. But Amber's going to let us know as soon as it does drop. She's been refreshing all morning on the docket. Ooh. Defendant's motion for a curative instruction. Is that the one? Let's see this. I want to watch what Mrs. R.A. is watching. Sounds really fun. I've got mail. Okay, it's a few pages long. Let's see if we can send this to the laptop and read it during the break. Come on. There it is. Finder. All right. Trying to get it up on screen. Give me just 1 second. All right, this is the motion that there we go. This is the motion that Mr. Alessi filed here. Let's see if I can do this. Make it a little bigger. And continuous view. There we go. All right. Defendant's motion for curative instruction regarding Exhibit 88 and its introduction to evidence of exhibits. Let's see if this is the right one. Now comes the defendant, Karen Reed, and respectfully moves this honorable court to issue a curative instruction as set forth below to address the intentional misconduct of the Commonwealth, which occurred before this jury and this court on June 9, 2025, regarding Exhibit 88. Ms. Reed also requested exhibits YYY, ZZZ, AAA, and BBB, which were marked as part of Ms. Reed's motion for mistrial with prejudice, be admitted into evidence. Ms. Reed respectively submits that the instruction issued by the court on June 9, 2025 was not curative or otherwise sufficient, This point is underscored when one reads the deep level of prejudice that exudes from the questioning of Dr. Wolf by Attorney Brennan, which is attached as Exhibit A. With this intentional misconduct being deeply and directly intertwined with the central issue in this case, whether or not an impact between Mrs. Reed's Lexus and Mr. O'Keefe even occurred, Ms. Reed's constitutional right to a fair trial and due process compel the requested for further curative instruction by Your Honor. Going back to read the footnote, it says, attached to Exhibit A is the recross examination of Dr. Wolf by Mr. Brennan and the redirect of Mr. Jackson. This is not exact transcript produced by the court, but rather a transcription created by the defense to the best of their ability from the recording available on YouTube. Go watch Recovery Addict right here for the best audio, beginning at runtime such and such. He didn't say Recovery Addict, though. This was created to offer context and clarity for all parties, if necessary. Ms. Reed does not waive and hereby reserves all her rights asserted in her June 9th, 2025 motion in open court for mistrial with prejudice. Continuing down, he goes on, he says, the intentional misconduct of the Commonwealth also wrongly impugned the credibility and competency of the defense witness, Dr. Wolf, by asserting that he did not properly account for the holes in the back of the sweatshirt and incorrectly posited to the jurors that the holes at the back of the hoodie sweatshirt of the decedent, Mr. O'Keefe, were caused by alleged events occurring on January 29th, 2022. See Exhibit A, especially the yellow highlighted text of Exhibit A, page 7, where Attorney Brennan appears to cut off Dr. Wolf from noting the holes on the back of the hoodie sweatshirt were the subject of cutting. This, therefore, must also be part of the curative instruction. On June 9th, Your Honor initially proposed the following language outside the presence of the jury. Quote, Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt, and I instruct you that these holes were made by Mrs. Hartnett during the course of her inspection and sampling on May 18th. The court then instructed the jury with the following language. It should be identical to what you proposed, but no. So, jurors, I instruct you that the holes were made by the criminalist, Miss Hartnett, during the course of her inspection and sampling of the sweatshirt. Proposed curative instruction. Ms. Reed respectfully proposes the following language to address the misconduct and its harm to Mrs. Reed. During the cross-examination of Dr. Wolf, but Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that these holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that these holes did not come from any alleged event on or about January 29, 2022. Looking at the footnote, Exhibit B is a portion of the discussion between Your Honor and Mr. Alessi before the jurors returned. As with Exhibit A, is an exact transcript. It was created by the defense. Here's the YouTube video. Recovery Addict has better audio. Yesterday, the court agreed to enter that into evidence and allow into the defense to display YYY, ZZZ, AAA, and BBB. This has not been done yet. This information regarding the clippings from the crime lab still needs to come into evidence and be displayed to the jury. It unequivocally establishes Maureen Hartnett cut clippings out of the gray hoodie sweatshirt, and that the damage was not from any alleged event on January 29th. Conclusion. For the foregoing reasons, Ms. Reed respectfully requests this honorable court instruct the jury with the above proposed curative instruction in furtherance of Ms. Reed's constitutional right to a fair trial and due process, and enter exhibits YYY, ZZZ, AAA, and BBB into evidence. This is an inflection point for this trial and public confidence in the judicial system. Everyone's watching you. Everyone's watching. And then it's signed, of course, by Alan Jackson et al., Elizabeth Little, both on there. David Dinetti, Robert Alessi. I like that his signature is just R.A. Robert Alessi, R.A. Nice. I approve. I approve. And then, of course, we've got the certificate of service, and attached probably is a document somewhere that we're not seeing. So, that's a nifty one. That just posted. And then we've got the motion for reconsideration of the court's order excluding testimony of Dr. Elizabeth LaPosada regarding bite wounds. That's what was argued already, so we're not going to read that whole thing. But where did he propose that when she ruled that? Why did he propose? He asked that more information be given, and she was frustrated that he asked that he wanted to amend it to include more information, and instead she shortened it. So. Have you addressed her talking to her hand and then look she had when she saw camera caught her? When was it? I could go back and look on the replay. Was it today? What happened to the attorney that was the juror last time? Where did she go? I believe she was brought on specifically for jury selection. That's when she was sitting with the group. I think she's been here other days, but her role was at the beginning of trial. Yeah, and nothing was stricken. Oh my goodness. I would need some sort of timestamp to find it. I've got everything, Joni, but gray in the U.S., gray in the U.K. Amber, I did. I just read one of them. I'm not going to read the other because it was argued in court and ruled on. But the one that we read was the one that the judge said she's not going to even look at until the charge conference when the jury gets the charges and the instructions just prior to deliberation. Britt Bottoms gifted a membership. Thank you, Britt Bottoms. Please replay AJ's comment this morning. Which comment? He's made a lot of comments. I don't have outrageous saved right now. I can't cue to that one. Forgot to ingest it into my system. Let's see. Virginia said they took the witness outside yesterday and told her that she couldn't say dog bite. She fixed that by saying animal bite. The problem was she wasn't allowed to say anything about dog or animal until just before she came in today, and no one talked to her then. So she was asked questions after being told she can't talk about it. She was asked questions, and she's trying to very carefully answer using the terminology that Mr. Jackson is including in his questions. To sort of, I mean, she's following his lead. But she took a little bit too much liberty and said bite, and that got her in trouble. And the result was the judge basically granting Mr. Jackson the permission to lead, which you normally only get with a hostile witness, but you also see it occasionally when you have a minefield, as Mathis put it, a minefield of judicial rulings that you have to guide a witness through. You could see the frustration in the witness's face as she knew she was being led through and just asked to say yes, 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 yes. She was frustrated with that. Let's see. Ooh. Mimi D, member for 25 months. No place I'd rather be. Congratulations. Love the pink courthouse. Looks great. Did you get a chance to ride the new toy? Yes. I rode for like half a mile, and my kids have ridden the other 9 miles or so that it's gone. But the new bike, I got on it. The e-bike, I got on and I started pedaling. I'm like, okay, so it's a little hard to pedal. You know, it's a heavy bike, weighs 67 pounds. And then I put it to pedal assist 1, and it's like, zoom, it just took off. And it was like, oh, wow. This is good. Pickle Festival in Pennsylvania on August 5th. I might still be in Idaho for that one. Might be at Bear Lake. I'll see if I can get the outrageous comment over lunch. I don't want to miss them coming back and be behind on anything. Let me get rid of this motion since we've gone over that one. All right. Pickle Festival, Dallas, November. Ooh. I don't think I've ever been to Dallas other than I think I had a layover or something there. I think that's it. Josh, 16 months, nothing else to say, just send in a milestone chat. Since it's free, Josh, thank you very much. But Josh, incredible mod and an attorney level support of the channel. Josh, thank you very much. Many of you also know you've received gifted memberships, as he's been quite generous with the gifting as well. So thank you, Josh. Are we going to Brian Koberger? Probably not in person, at least not for all of it. I have not ruled that out. We have some great court watchers who are planning on being there, and it will all be. I won't be able to get anything different than I can get right here, straight from the court feed online, unless I film it outside. And we're working on that. So possibly with Nicole Goodman and the live view and some outside court feed. We'll see what we can do. I'm here and can show you where the X is on the road where JFK was allegedly assassinated. Wow. Fabulous zoo in Dallas. Is it a petting zoo? Or is it like the sharp teeth, sharp fangs, sharp claws? Koberger is due to start August 11th if the date holds. What brand model of e-bike did you purchase and did I buy online? Yes, I did. I bought a Pucky Puppy. That's the brand. I know it's a funny name, but the brand Pucky Puppy, every model is a dog breed. And so I bought the Boxer. I can send you a link if you guys want. It's a very expensive bike. But I got it on a sale. Hang on one second. If I can find it. Here we go. Got it. All right, I just posted a link. It is an affiliate link, so if you make a purchase, Amazon would reward me with some small financial donation. But it's on sale again. That's always nice. Sometimes the price goes up a little bit, a couple $100 higher. But I did get it in the gray color. Things I like about it, it has a capacity of 400 pounds for carrying, so it can hold me and all my camera gear and batteries and tripods and everything else and still have room to go. It's not something that will power you up a mountain without pedaling. It has a pedal assist mode. It's a Class 2 e-bike, which is generally the class that's most supported in areas on trails and everything else. Treated in most areas like a mountain bike. But it also has an 80-mile range, depending on usage and weight, and it's just built well. So. Do they have a Dausch? I can never say this word. A wiener dog. It's a wiener dog, right? Do they have a wiener dog version? They have a trike. This particular bike, I would recommend. If I would to buy it again, I would buy the Boxer S version, which has a step over. So instead of having the cross, let me see if I can show you. Instead of having the crossbar between the seat and the I don't know, the pommel area, it's a horse thing. there's no crossbar, so it's easier to step over and onto. I think, especially watching my kids try to get on the bike, I would have gone with that had I known it would be difficult to get on. It's good for people up to 6'6" is a maximum height, and 5'4" is sort of the minimum. My kids are shorter than that, and they struggle. Boxer S. I would have, even as a guy, it's easier to stop and just, get on, get off. It's just, anyway. I got a bike rack as well. I got a dual slot bike rack. This is the trailer hitch mount. So it just rides in the back of my car. So it's pretty good. This one, it's rated. It comes out of the factory just ready to go, and it's class 2. But you can go into the settings and you can change it if you want to have the max speed that it will power you up to be 61 miles an hour is the top. Just for the record, that's like dangerous. Don't do that. But can you take a running leap from behind the bike? You could. The seat is incredibly, it's like, I think it's built by Lazy Boy. It's massive. It's a massive cushioned seat, and the suspension is incredible. Do you see the clip of the woman running after Mr. Wolf yesterday? I couldn't stop laughing. I did not see it. Is it AI? Yes, 61 miles per hour. That's too fast, by the way. They do make a tricycle. They do make a tricycle version, and they're awesome. No, it was real. The woman chasing after him. So a recliner on wheels, pretty much, Jennifer. I think you pretty much nailed it. Although you can go in the settings and make it. You can require it to have you pedal in order to give pedal assist, or you can just have throttle only, or you can change it however you want it. It's very customizable. And we've gone 10 miles or so on the bike now, and we've taken it's used 1/6 of the battery, and I don't think anyone's pedaled. They're all just full throttle all the way. Do you shift gears? It does have 7 different gears, but you don't need to if you just want to use the throttle. Yeah, I'd get a copyright strike on playing some of those videos. All I need is recline assist. Is it street legal? It comes with headlights, taillights, brake lights that activate with when brakes are used. It comes with mirrors, front basket. I haven't put on the front basket yet. Fender rack, pannier, bags on the back. It comes with all that. And as a matter of fact, in my town, it's illegal to ride a bicycle on the sidewalk in my town. It's also illegal to skateboard or rollerblade anywhere in my town, unless the only place, I kid you not, the only place it is legal to ride a rollerblade, skateboard, or ripstick in my town is in a crosswalk. Then you're allowed to ride it back and forth in the crosswalk, but you can't ride it on the street and you can't ride it on the sidewalk. So yes, it's street legal. Did I see my above message? Yes. See, I just got a message. Insurance approved me getting a new wheelchair. I have a power assist wheelchair by September, so finally decided to do away with the manual wheelchair. You're going to be popping wheelies in no time. It's going to be awesome. You want to ride the bike? So, what can you show me again what you were just saying? Vroom vroom. Okay, he comes in. He's like, "Can I ride the bike?" All right, I have to be out there to help you. Bring the e-bike when you go to Dallas Pickle Fest. Then use the bike to visit us at Fort Worth and Thomas with the weather watch, a little north at Fort Worth. Sounds awesome. I could go like long distance. I was watching the some of the footage out of L.A. Last night, and just amazed at the number of e-bikes that are out there, and like full-on electric dirt bikes that are used. One of the guys that was actually running on one of the live streams has a bike that can go 0 to 60 in 3 seconds, and he's just tearing around through traffic, running stoplights, up on the sidewalk, jumping curbs, all electric. But those run $5,000 or $6,000 for those. Cielo, I'm not sure if you get a chance to do it before the channel got a copyright strike and will be taken off the air for 7 days. It hurts quite a bit. Okay. Post link again, please. Link of the bike. There's the link of the bike. Next big one is probably Corey Richens. We'll probably have some small ones between those, though. Depends what the decision is on Corey Richens. Jen, the brand is Pucky Puppy, which is sort of, I will tell you, they come packed very, very well. It's a 2-person lift to handle the box, but all e-bikes are like that. All e-bikes are heavy, much heavier than a regular pedal bike. But I used a crowbar to open mine because it was packed so well, and it's all cardboard. I guess I could have used a knife to cut it, but I used a crowbar, and it was just glued down, stapled down in this big bicycle box. Bud Dial, I bought a spare battery. They had a deal where if you bought the battery at the same time you bought the bike, it would be $99 for a spare. So I got the $99 spare. Normally they're $400, I think, to get a replacement battery. So now I have 2 batteries, so I guess I go like 160 miles or so in theory. Josh gifted 5 memberships. Thank you, Josh. Appreciate it. Lisa says, I'll be boots on the ground for Corey Richens. Lisa, that sounds awesome. Are you going to be up there day in, day out? Corey Richens should be sooner, but we're just waiting for the date to be finalized, if somebody can check that for me. Megan Jackson starts today in Conway, South Carolina. Richens is back on, but what's the date it's back on? Is it back on original schedule, which is very, very soon? Like it might overlap with this trial type. Regina, thanks for gifting a membership. This has been a long break. It was supposed to be 10 minutes. The judge was going to come out and sort out everyone's problems if they couldn't work together as equals. Yeah, if everyone can commit crimes and be prosecuted on a timely schedule, that would be great. Catesy Wisher, this is or Catsy Wisher, sorry. The Corey Richens story is crazy. The defendant, Corey Richens, is accused of poisoning her husband with a fentanyl in a drink and also in a sandwich, but that didn't work. Poisoning him and killing him for control of the money and possibly life insurance as well. Also because he didn't approve of her
You
buying
are
a big
unmuted.
house. After he died, she wrote a book for children, Are You Still With Me? And went on a national book tour on Good Morning America, everything, talking about this book about, grief, when you lose your dad. We're unmuted. Here we go. Bree, thank you very much. Acknowledge the mods day.
Counsel, why don't I see while the jury's coming in?
Another sidebar. What is this? I don't think this is mine. Don't know how to open it. This would be sidebar number, what is it? Is it 6? Sidebar 6? Yes, I still have the taillight. I have not dismantled it yet. Can you mount it to the e-bike? Imagine I could. She didn't get much attention on her book tour. I think she got a ton. She was on Good Morning America. I think she was on like 6 or 7 national talk show, morning show things. And her book was like ranked quite highly on Amazon, I thought. I could go for a salad sidebar. Oh, several times. Judy, that's why I don't rollerblade. Do not rollerblade. That's just a prescription to land on your butt and hit your head. Put a speaker inside the taillight and make it say woof. Why is this witness not allowed, Elizabeth, this is a good question. Why is this witness not allowed to say John's arm injuries were caused by dog or animal bites when the prosecution can say without any objection from the judge that it's being struck with a vehicle? This witness, during voir dire, was asked questions about her expertise, and the judge ruled that she was not able to be qualified as an expert in that area regarding dog bites. So she's not allowed to say that. She did allow her to say it's consistent with an animal attack, but she said it's consistent with an animal bite. Yeah, bite me. If you don't like the delivery charge on the e-bike, what you can do is you can buy it straight from Pucky Puppy instead. It's the same price, but they have free delivery. It's the same end price, but they say free delivery. It's just more expensive bike. So it ships out of California.
Yes.
On the court's bench, there's an item that I'd retrieve back.
Miss, we need that marked for identification.
I need all 3 of them marked for identification.
Okay, and we'll do that afterwards. Just please go ahead.
Do you see any x-rays?
I did.
What were the x-rays of?
The x-rays were taken of Mr. O'Keefe at the medical examiner's office, and they were x-rays of his chest, his arms, and his legs.
Did you specifically review x-rays of his right appendage? Hand, forearm, arm?
Yes, they were included in the x-rays.
Have you seen x-rays before?
Oh, many times.
How many times?
Thousands, probably.
Is part of your job to review x-rays?
Oh,
to make
absolutely.
a determination of whether or not they indicate broken bones, fractures, hairline fractures, things of that nature?
Yes, it's part of the medical legal autopsy to study the x-rays of the deceased.
That's done in the ordinary course of being a forensic pathologist, is that right?
Yes.
Are you trained on how to read x-rays?
Yes.
You have to be a radiologist to read an x-ray as a medical doctor?
No.
Medical doctors do that all the time, correct?
Yes, it's part of general medical training.
And is it also part of specialized training for forensic pathologists?
It falls under the rubric of general radiology that a doctor knows. There are some specialized areas in forensic where you have to understand like decompositional changes that you can see on an x-ray that aren't something that you would see in a clinical setting.
Taking the appendage one item at a time, did you look at Mr. O'Keefe's x-rays of Mr. O'Keefe's right hand?
Yes.
Did you see any defect in the bones of the right hand?
No bony defects, and the tissue was normal.
Did you take a look at the x-ray of Mr. O'Keefe's right arm?
Yes.
Did you notice any defects at all in the bones in the right arm?
No, the bones in the right arm were intact.
No breaks?
Correct, no breaks.
Fractures, hairline fractures?
No.
Did you look at the upper arm x-ray of Mr. O'Keefe?
Yes.
Did you note any defects in the bony structure of Mr. O'Keefe's upper arm?
No, the bones were 100% intact.
No breaks, fractures, hairline fractures?
Correct, none of those.
Was there any indication in your mind, based on your review of those three x-rays, the hand, forearm, the arm, that arm had suffered any kind of bone trauma at all?
Okay. Sustained.
Was there any indication, based on your review and your expert opinion, that his arm had been broken, fractured?
No, the bones were intact. No breakage, no fractures.
Thank you.
Okay.
That's big. That's big.
Examination.
Thank you.
Here we go.
Good afternoon, Dr. LaPosada.
6 minutes till the afternoon. Good afternoon.
That's okay. You wrote a report in this case, doctor?
Yes, I did.
Do you think that based on your analysis, was Mr. O'Keefe thrust backwards? Is that what you determined looking at his head injury?
That he was, I didn't understand. You had your hand in front of your mouth.
Sure, I'm sorry.
Yeah.
You talked about a head injury that Mr. O'Keefe had, that
Yes.
he suffered from?
Yes.
That caused his death?
Yes.
Was that caused by being thrust backwards?
Yeah, the motion was upwards, down.
Okay. And the way you just showed it could be a fall.
Correct.
Did you have an opinion looking at his wound that he was thrust backwards?
What do you mean thrust? His body went backwards. There may have been some applied force to it.
I don't know about thrust. I'm asking if you have an opinion. Your words. Do you have an opinion about thrust?
What do you mean thrust?
Did the forensic pathology diagnosis mean Mr. O'Keefe's body was thrust backward?
If you want to say thrust as indicating movement, that it went backwards, then you could say it was thrust.
Okay. May I approach?
Yes.
I'm showing you page 2 of your report, Dr. LaPosada.
Yes.
I'm just going to ask you to read it, not out loud, and then I can ask you the question. I appreciate it, but I want to
Yes.
take a look.
Yes.
Are you familiar with that?
No, absolutely.
So, Dr. LaPosada, what did you mean when you described that Mr. O'Keefe's body was thrust backward from a standing position?
I mean that he was standing upright and his body had momentum and went down and hit at the back of his head. So when it was thrust backwards.
You cannot tell forensically how much momentum he had, can you?
No, we don't do those analyses.
You can't tell if anything caused that momentum. based on the head injury, can you?
What do you mean causative? It was caused by his body went backwards.
Yes. And so the amount of force causing him to go backwards, that's not something you can determine from the head wound, is it?
No, I can't tell you the amount of force. It was significant because he had the massive skull fractures.
Did you say it would be significant?
Yes, significant force.
In modern medicine, there are a number of different machines that can help us see the brain, like a CAT scan, perhaps?
Sure.
MRIs?
Yes.
Would you agree with modern medicine that the use of MRIs and CAT scans and other tools give a clinician equal, if not better, opportunity to examine the brain as actually cutting it and holding it in your hand?
No, the actual gold standard is the pathology, to be able to have the brain in your hand, look at it with your naked eye. And we have conferences in the hospital where we meet with radiologists and say what we find at autopsy and see if their radiology was correct.
Can CAT scans and MRIs show contusions on the brain?
They might.
Subdermal hemorrhages?
Subdural hemorrhages. Yeah. Yes, they
Herniations?
can. They can.
Do you have any doubt about the modern medicine and the use of MRIs and CAT scans? Do you think they're inadequate in any way?
Well, I'm not a clinician, so I don't use those to diagnose diseases in living patients.
Dr. LaPosada, have you ever had any experience studying the brain in real time, clinically, going and opening somebody's skull and treating the injury before the person dies?
No, I'm not a neurosurgeon.
You don't have any neurological expertise, do you?
I'm not a neurologist. I'm not a neurosurgeon. I'm a forensic pathologist.
Do you have any clinical experience at all where there's an acute head injury and you're making an effort to observe it and analyze the injury as it progresses in an attempt to save the person's life?
I don't treat or diagnose living patients.
I understand, but as far as your background, have you ever had any experience, clinical experience, showing the progress of an actual brain injury and trying to treat it?
I understand the physiology of what happens to the brain when it is impacted by something, whether it be a bullet, a boulder, a fall. So I know what happens to the body to cause the changes from that trauma. I don't treat people for those injuries.
In observing a brain that's in trauma and making determinations of how long it's viable or whether the person will expire, do you know the process that a neurosurgeon would go through in order to fight to preserve the person or save the person? Do you know the step-by-step process that they would undertake?
To do what?
To try to operate or save somebody from a head injury, from a brain injury.
I'm going to allow it because of prior testimony.
Well, it depends on what the brain injury is. If you have head injury and you have bleeding on the brain that's pushing the brain one way or the other, it would be a subdural. Then a neurosurgeon would come in and try to take that blood away so it doesn't compress the brain. So that's something that neurosurgeons do to treat head trauma. They can also put in drains into the ventricle of the brain, and that can relieve pressure in the brain because that brain swelling is a bad thing. So those are some of the things neurosurgeons do to treat brain injuries.
And can they remove part of the skull to relieve pressure?
Oh, yes, they can do that. It's called a craniotomy. They can take out part of the skull if they need to.
So there are a number of different steps that a neurosurgeon can take when someone suffers acute brain trauma to try to save the person, isn't there?
Well, the job of any doctor is to try to save a human life if you treat living patients. So certainly a neurosurgeon would evaluate the patient and decide if there's any treatment needed that could improve the patient.
When you've had cases in the past as a medical examiner where there have been issues regarding brain injury, wouldn't you agree that you have sought outside consultation with people who have a higher degree of specialty in brain injury than you?
Sometimes what we do is when we're examining the brain, we can call in for a conference and have a neuropathologist come in and review the brain with us.
And back when you were a medical examiner, you did that on a number of occasions, didn't you?
Yes, that's routine.
The reason why is because there are different specialties in medicine, and some are different and separate than your specialty, correct?
Of course.
And a neurosurgeon or a brain surgeon, it would be a different specialty than yours.
Yes.
And they're focused on the brain, yes?
A neurosurgeon does brain surgery.
And so, how many times in your career do you think that you've assisted the help of neurosurgeons to take a look at brain study to help you?
I've never needed to speak with a neurosurgeon to look at a brain. Sometimes we call in neuropathologists and we have a forensic neuropathology conference where we look at brains with the interns and residents.
How often would you call a neuropathologist?
Maybe once a month we would have a routine conference.
And again, the neuropathologist, that's dealing with a person's brain after they're already died.
Correct.
So it's not a clinical setting or a clinical experience of actually watching the brain at work and seeing the injury as it progresses.
We don't do neuropathology like that on living people. The person is deceased.
You had an opinion to the jury today, and you said that you believe that Mr. O'Keefe died within 15 minutes?
Yes, I think that process would start within 15 or 20 minutes.
Is that to a reasonable degree of medical certainty, that opinion?
Yes, based on the severity of the injury and the brain swelling.
You're aware that there are numerous level 1 trauma centers around the country that deal with brain injury, right?
Sure.
And the idea is that people suffer all types of brain injury, and if they are given medical attention in a reasonable amount of time, there's a chance they can be saved, yes?
It's possible, but many are so severe that they cause death no matter how fast they can get medical attention.
In fact, every day when people get the right attention or proper attention, they're brought to level 1 trauma centers around this country to try to help them or save them. Isn't that fair to say?
I would hope so.
Do you think?
Sure.
When you looked at Mr. O'Keefe's brain, obviously it's after he already expired, correct?
Obviously, yes.
And so you didn't have any clinical observation of the progress of his injury that night, did you?
I was not observing him. I did not observe how he got his injury.
When you gave an estimate or you give an opinion about how long he was alive for, are you aware that there's certain tests that are done by neurosurgeons when people are suffering brain injuries but there's an attempt to save them?
Sure.
Have you ever heard of a Guzman coma score?
Glasgow, you mean?
No, but it's Glasgow, but you've heard of Guzman?
It's called Glasgow coma score.
Have you ever seen the assessment that a level 1 trauma center goes through when they're trying to save somebody with a brain injury?
I'm generally familiar with the emergency procedures to save somebody's life.
Have you ever read any statistical studies attempting to correlate the brain injury with the time somebody would live for?
I'm aware of that, and I see that in my practice of people who have survived brain injuries and die of something else. Then I can look at the brain and understand how the brain can heal or react to injuries.
And many people who suffer coup contra coup will go into a brain surgeon center, and many of them pass after time, don't they?
Now, every case is different.
Right. Some might live for an hour, hours, weeks, months, or survive the injury. Isn't that fair to say?
It depends on the case.
In this case, you don't have any objective criteria to identify the amount of time Mr. O'Keefe would have lived if he had the appropriate help. Isn't that fair to say?
I don't think it would have been effective because there were massive skull fractures to the base of the skull, and there are cases where the amount of force and energy applied to the head, causing skull fractures, breaking the neurons, causing the brain swelling, despite rapid medical treatment, those people cannot be saved. They can't effectively stop the brain swelling.
Many people can't be saved. Did you know that about 1/3 of them do get saved?
I don't know what you're talking about. 1/3 of everybody has different sorts of injuries. 1/3 of what?
With a clivus fracture, coup contre coup. Are you aware that 1/3 of those patients survive if they get the proper treatment?
It depends on the amount of force.
Okay. Are you aware that a study would show, have you ever read a study by Isaac Wolf on clivus fractures?
No.
Have you read any studies on clivus fractures?
Clivus fractures? Yes, I understand what clivus fractures are. It's a part of the base of the skull.
Okay.
And
have you...
Okay, go ahead.
Please. Did you want to
No,
say?
you go ahead.
Oh, I'm sorry. Have you read any studies that tell you with the proper treatment, despite these potentially catastrophic injuries, that 1/3 of patients can survive?
No, but that's not the case we have here.
And so in this case, I asked if you had any objective criteria. You don't have any objective criteria about the progress of Mr. O'Keefe's wound that can be a basis for you to conclude that he would have died in 15 minutes. Isn't that fair to say?
No, I understand what happens to the brain when it gets that sort of injury. I understand the time course and the physiology. I've seen hundreds of individuals who've had brain injuries. Some survive for a longer period, some die earlier, and it depends on the amount of force and the amount of brain swelling. And in Mr. O'Keefe's case, we had the massive skull fractures of the base of the brain and immediate swelling and subarachnoid and subdural. So he had a large force applied to his head, which caused the brain swelling and the and the progression of the brain stem down through the foramen magnum that stopped the brain. It was a very forceful impact.
You examined his brain after you looked at photographs. You can't tell us objectively when his brain swell started.
It started immediately after impact.
And you can tell us what the progress of that brain swell was by looking at his post-mortem photos.
By looking at the post-mortem photos and the post-mortem examination, I can tell the degree of force from the extensive skull fractures that were present.
What was the degree of force?
It was medium to large.
Well, that's a wide range. What do you mean? Quantify medium
So I'll
to
strike
large,
the comment.
please.
Ask the question, Mr. Brown.
What does medium to large mean?
Enough to cause a lot of fractures to the skull. He didn't just sit down and lie down.
If he sat down and lied down, he probably wouldn't have fractured his skull, correct?
That's obvious, yes.
Right. And so when you're telling us you can identify that he immediately died or died within 15 minutes, I'm asking you for objective criteria. For you to give that opinion, I'm asking you what objective information you have. And so you said that there was a large amount of force, correct?
Sure, because there were massive skull fractures, and there's a lot of energy transmitted to the brain, starts swelling immediately.
How do you know this wasn't medium force and not large force?
Because of the extensive number of skull fractures.
So are you saying it was medium or large force?
Medium to large.
Okay. How much force is that? Can you quantify it?
No.
What other objective criteria do you have to support your opinion that Mr. O'Keefe died within 15 minutes?
My training and experience of seeing thousands of deceased people from head injuries and knowing some of their clinical course when they get immediate medical treatment, they don't survive.
But you would agree many do.
Depends on the case.
Right. And in this case,
She doesn't see
you
the ones
didn't
that
have any
survive.
opportunity to observe the progress of Mr. O'Keefe's injury that night, correct?
Objection, Your Honor.
I'm going to allow that.
I wasn't there.
You had-
The body told me what happened to it.
You have no assessment of the development of his brain injury and how much time it took that night, do you?
I do, from understanding the significant skull fractures and the swelling of the brain and the compression of the brainstem that all happened very rapidly because of the amount of force that caused all those skull fractures on the base of the skull that actually then hemorrhaged into his upper eyelids. That's a large amount of force.
Was gross edema found on his brain?
I think it was swollen, yes.
But was that a finding?
Yes.
Where did you see that finding?
Well, in order to have the herniation of the brainstem, the brain swells.
Where did you see that finding?
I can't answer that. I just know it from understanding, looking at the pathology.
So at the end result, at some point, Mr. O'Keefe had gross edema.
In order to get the brain stem hemorrhages, the only way you get that is because the brain has swelled. And there's no, after injury, tissue swells, and there's no place for the brain to go when it swells except down into the natural hole in the bottom of the skull where the spinal cord goes down. So that's where the pressure goes. So that seeing the brainstem herniation tells you that the brain has swollen a lot.
Undoubtedly, but it doesn't tell you when it began to swell or the progress of that swell, does it?
I don't know what you mean.
You see inevitably because of the swelling, there's the suffocation, but when you see that, you don't know when the swelling began or how quickly it progressed. You can't tell that from an autopsy.
Yes, you can, because of the severity of the skull fractures. I know there was a lot of force, and that force applied causes you to go unconscious, then your brain swells. If there was just like one skull fracture, then that's a little bit different. But this was massive skull fractures on the base of the skull. So there's a lot of force applied. So I know because there's a lot of force applied to cause the skull fractures, that the brain would swell rapidly.
You would be unable to identify the rapidity of the swelling if you don't know the amount of force. Isn't that fair to say?
Well, I do know the amount of force because of the amount of skull fractures.
In what you know is, in your words, medium to large force.
Yes.
You've heard of periorbital ecchymosis?
Yes.
And that's sometimes called raccoon eyes?
Well, periorbital ecchymosis just means bleeding and bruising around the eyes.
And you saw the bruising around Mr. O'Keefe's eyes, didn't you, in the photographs?
Well, it wasn't bruising caused by blunt force trauma to the eye. It was bleeding in the upper eyelid because the plates above the eye and the base of the skull were fractured by the brain hitting it. So, and that's a result of basilar skull fractures and not the application of force directly to the eye.
Would you agree it takes a few hours for the bleeding to accumulate in the person's eyes?
No. As soon as you break the skull bones and the heart's pumping, the blood comes out of those injuries.
So
it starts to accumulate right away. It starts within minutes. You can see it.
So you would disagree with the suggestion that it takes at least 1 to 2 hours for that bleeding to occur in the eyes. You disagree with that?
I do disagree with that. It starts immediately.
Do you have any studies that you've relied on or literature or support for that?
I understand the physiology of what happens when you get those skull fractures and the density of the blood vessels. And if your heart is pumping, you pump the blood out those broken blood vessels into this small area above the eye. And it can happen within minutes.
Do you have any studies or literature to support that?
It's my training experience. I can't cite you a particular article at this time. I could certainly go look it up and bring it to you.
Okay. Let me ask you questions about the wounds to the back of Mr. O'Keefe's head.
Yes.
You see a linear abrasion?
Yes, vertical lines, yes.
Now, would you characterize this as a classic wound caused by falling backwards and landing on your head?
What do you mean every wound is different?
Every wound is different?
Sure, every person's different. Every way you get injured is different.
And so if somebody falls backward on their head and suffers the basal fracture, the wound from your perspective can look different.
It depends on the impacting surface.
Wounds on the same surface, say two people fell on the same surface, could they have different wounds on the back of the head if they suffered the same injury?
In theory, if they fell, if they rotated their body, if you could reproduce something exactly, then you would see the same wound patterns.
This wound pattern is typical of falling backwards on a hard surface, isn't it?
We know it's from falling backwards and striking something hard.
Can the frozen ground be hard?
A frozen ground can be hard, but it doesn't fit the pattern in this injury.
We'll get to that, but is it hard enough to cause a basal fracture?
It can cause a skull fracture.
The frozen ground is different than a sheet of ice, right? It's not smooth and flat like a sheet of ice, is it?
It could be, I guess.
Okay. You mentioned there's some granular patterns in this wound.
Yes.
Didn't you?
Yes.
The area in front of 34 Fairview, the frozen ground, do you know if there was any impediments in the lawn that was frozen?
In the what? Oh, the lawn?
Yeah. Yes. Sorry.
Yes, I saw the scene photographs of when the snow was removed, and it was like winter lawn grass. So it was some green, some brown that was pushed down, and like straw that was going different directions, which wouldn't give you that pattern.
Did you see the exact area where Mr. O'Keefe last moved?
I saw that general area, and there were a lot of photographs, yes.
You say general area. Can you tell us that you saw photographs of the spot where Mr. O'Keefe was lying when he was found?
Yes, that general area.
Could you see the ground where his head was? Can you identify that?
Yes, with the scene investigation, they shoveled the snow off of that area.
And you had never had a chance to go out to that scene yourself, did you?
No, I just looked at all the photographs.
You cannot see what's under the grass and the dirt, can you?
Well, dirt's under the grass.
Well, do you know if there's any rocks or impediments or bumps?
It was a smooth surface covered with grass.
It was a smooth the front lawn was a smooth surface?
It was a flat surface.
Flat.
Covered with grass.
Okay, and do you know what was under the grass, whether there was any pebbles, rocks, debris?
I didn't see any.
From the photo?
Correct.
But you don't have any first-hand knowledge that exact area where he ended, what the turf was like, do you?
I saw photographs of that lawn where they removed his body from.
So you're relying solely on the photographs, is that fair to say?
Correct.
Do you know if Mr. O'Keefe was wearing anything that could cause abrasions when he landed to cause that scraping pattern in addition to the linear abrasion?
He did have a baseball hat on, but that would not cause that pattern.
The area of the abrasions, is that in the area of the level of where a baseball hat would be on the back of somebody's head?
It could be.
Could be. If somebody hits the ground and falls backwards, can they slide?
If they're on an incline.
What if they're thrust?
Well, if you fall backwards and you fall backwards on an incline, your body might move.
Well, what if you fall backwards on flat ground? Does the body, can it move after it falls?
Not really, maybe a little. If from the From the momentum of the impact, it might move slightly, but not really.
So when a person falls backwards and lands, you don't think their head has any room for movement?
Not significant.
Well, not significantly, maybe just a quarter inch, half inch.
No, it's possible.
Okay. And did you see the scrapes around the wound of Mr. O'Keefe's head?
Of course I saw them, yes.
Okay. And they're all within, what, about an inch?
What are you describing? What part? Are you describing the tearing, the laceration of the scalp, or the vertical abrasions?
The vertical abrasions.
There were maybe an inch, inch and a half.
Inch and a half? Do you think that if someone fell backwards and landed on the head, they could move an inch and a half?
Well, he landed on something that had a ridge on it to cause the laceration in the scalp. And then with a little bit of movement, those vertical scratches were caused by some kind of like pebbly-like surface.
You mentioned that the orbital bones were broken and you had opined that it was caused by the brain. Do you agree that a brain is very soft, consistent with, for example, tofu?
Oh, gross. No. What do you mean? It is soft.
Is it that soft? Is that the texture of it?
Well, it depends on what kind of tofu you have.
Okay. Do you think that the orbital could have broken when the break on the back of the head split the skull and then would cause the orbital break instead of the brain?
The orbital plate fractures, if you look at the base of the skull after you take the brain out, you can see the fractures go up from the back to the front into the orbital plate. Sometimes when you fall backwards, the brain can also slap those orbital plates and cause some damage, but I could trace the fractures from the point of impact along the base of the skull to the part of the skull over the eyes.
Do you think the base of the skull break, when it separates, could have caused those orbital fractures?
I don't understand your question.
Okay. When Mr. O'Keefe incurred that head injury,
yes,
the basal fracture, do you think that the pressure, the damage from that basal fracture, the separation, could have caused the orbital breaks in his eyes?
Well, the fracture of the plates above the eye, when the blood is still pumping, there's a space there where the blood can come down into the upper eyelid.
So you described the brain as causing that break. I'm asking you, could it have been from the basal fracture, from the skull fracture? Yes,
the fracture that was caused by the impact to the back of the head, radiating to the front of the base of the skull.
So when you told us on direct it was from the brain that caused those fractures, was that just a summary, or was that to a reasonable degree of medical certainty?
Well, sometimes the brain can also, in a fall, flap and hit those, but in this case I could also see that the skull fracture started at the back and came to the front, but it could also be contributed to by the brain hitting those delicate bones.
I guess my question is, when you've provided the opinions generally of what you believe and what you've seen, are these general opinions or are they actually specific opinions based on the facts of this case?
They are opinions based on my examination of this case, but all that's based on my 40 years of training and experience.
Well, when you told us about the brain causing those orbital fractures, you would agree with me, at least now anyways, that it very likely could have been the basal fracture that caused those breaks.
Yeah, both.
It could have been both?
Sure.
Okay, could it have been just the basal fracture?
That's possible.
When you offered the opinion to a reasonable degree of medical certainty, had you considered the basal fracture as the source of those breaks?
Of course.
Is there a reason you didn't share that with us and you just said it was the brain?
I had no reason not to share it.
Okay. Was there any depressed fracture to Mr. O'Keefe's skull?
No.
Can you tell us a little bit about a depressed fracture? Depressed fracture is different than what we saw with Mr. O'Keefe, isn't it?
A depressed fracture is when something fractures the skull and then pushes the skull and moves the skull inward. This just had a fracture, but it didn't move the skull inward.
And you've seen depressed fractures in your practice over 40 years, did you say?
Of course.
In those 40 years, depressed fractures can happen from sharp objects?
Sure.
Pointed objects?
Sure.
If someone hit a person in the back of the head with enough force, with like a hammer, for example, that could leave a depressed skull fracture, couldn't it?
Certainly. You can hit somebody on the head with a hammer and cause the fracture, and then the continued force will move that fracture into the brain.
There was no depressed skull fracture in this case, was there?
Correct.
You gave some opinions today about you gave some opinions about wounds on Mr. O'Keefe's arm. I'd like to talk to you a little bit about that.
Sure.
Could we have that photo brought up, please?
I wonder if he's going to open the door here a little wider. He has to be careful here.
Do you see all of those superficial abrasions?
Yes, I see patterned injuries.
Right. Would you agree that they're superficial abrasions?
Yes, they go along the skin surface.
How many punctures would you identify in that photograph?
Let's see, there may be some punctures like around the elbow, consistent with the teeth puncturing. Most of them are the teeth scraping along the skin.
I'm not going to ask you what you believe the cause was. I'm going to ask you just about the wound. How many punctures do you see?
Well, this doesn't show. There are other photographs which show more of them, but there's the little dot-like areas. You could call an area of skin puncture.
Can you tell us from this photograph how many punctures you would say are in that photo?
I didn't count them.
Well, did you suggest that there was more than one puncture on that wound?
I think I see more than one, yes.
Pardon me?
I see more than one on there.
Okay, could you give us a count of how many punctures you see?
Well, without looking at all the photos, I couldn't give you a correct number.
Okay. You've written a report, haven't you?
I what?
You wrote a report?
I did.
And in your report, you describe many of those abrasions as punctures, don't you?
Yes.
And a puncture isn't just a scratch. A puncture is a penetration of the skin, isn't it?
Yeah, a point-like penetration.
A puncture has a very specific medical meaning, doesn't it?
Yes, it's a point-like penetration of the skin.
Okay. And according to you, there are many punctures in that wound.
Yes, I can see 1, 2, 3, 4, 6 or 7.
Can medical professionals disagree on opinions about wounds and causes?
I suppose they can.
You also gave some opinions that you did not believe that Mr. O'Keefe's scratches were caused by having some impact with broken pieces of plastic or glass, correct?
Correct. They weren't caused by that.
Broken plastic or glass can cause a number of different angled wounds, can it?
It causes an array of irregular, random injuries.
It can have infinite different patterns, couldn't it?
Could.
There's nothing to hold a wound from a broken shard to be north or south or east and west. It all depends on how the force is impacted on the body, true?
I'm not quite clear on your question.
I'll try to do better. When you're talking about shards of broken glass or broken plastic, there is no set direction that they may cut somebody, is there?
Well, it would depend on the case and how those occurred.
Right. They can happen in many different forms as far as depth, yes?
Well, anything's possible.
Right. How about length?
What about length?
wouldn't that change? Couldn't that change depending on how the injury occurred, the length of the wound?
Sure.
And in this case, you talked about your opinions of injury relative to a motor vehicle, didn't you?
That was something I considered.
That's something you considered. Did you know much about the details of the motor vehicle in this case?
Yes.
Okay. When you considered your differential diagnosis, did you consider whether there was any DNA on the vehicle?
I didn't look at any of that.
I'm sorry?
I did not look at any DNA.
Did you know if there was any hair on the vehicle?
I don't know.
Did you consider the scene itself where there may have been a debris field? Did you take a look at the debris field in this case?
I know there were photographs of various pieces of plastic around the area where the body was found.
And do you remember where those pieces were found?
Somewhat, yes.
Did you have an opportunity to consider other evidence like a shoe in the area near where Mr. O'Keefe was found?
I know one shoe was on his foot at the hospital, the other was at the scene.
Do you know if his hat stayed with him after he landed on the ground?
The hat was in the area where his body was found.
Did you take a look at his pants, the back of his pants?
I looked at that, yes.
Okay, what did you see when you saw the back of his pants?
Well, because he had bled from the back of his injury and he was on a hospital gurney, some of that blood came down, so some of the blood was on the back of his pants.
Did you see anything else other than blood on the back of his pants?
I don't remember.
I'm sorry?
I don't remember if I saw anything else.
Did you look, when you were doing your differential diagnosis, did you look at any evidence other than physical evidence? Did you look at any data evidence?
I don't know what you mean, data.
Like data you would find on a cell phone?
No.
Did you look at any of the data evidence from the defendant's Lexus?
No, other than looking at the contours of the back to see if it had impacted Mr. O'Keefe.
When you were doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
Okay. So you didn't care to know anything about the car or the data in the car because you had already formed your opinion?
It did not hit him, so it was not relevant to my opinion.
Is that a different way?
By looking at the body, I could tell that there was no evidence of impact with a vehicle. So whether the vehicle was going slow or fast is not relevant.
And so you didn't try to get any information about the speed of the vehicle? It was totally irrelevant to you?
Correct.
And did you also disregard, well, let me ask you, do you ever look at statements?
I look at witness statements if they're available to me.
Were any of the defendants' statements made available to you?
I did hear some of them.
Did you consider the ones that you heard?
Of course.
Oh. Which ones did you hear?
I really can't answer that. I don't know what you'd have to give me an example.
You said that when Mr. O'Keefe first incurred his injury, you think that he was unconscious?
Yes, I think that the severity of the impact made him immediately unconscious.
So if hypothetically Mr. O'Keefe incurred his injury sometime around 12:32, is it your opinion that he never moved again until he was moved physically by somebody else?
Well, I don't know the exact time that he got the injury on the back of the head, but after that time, he could not carry out any purposeful activity.
May I approach sidebar, Your Honor?
Okay.
Mr. Brennan, sorry, let me turn this off. It's echoing. Mr. Brennan approaches the judge, says, "Judge, do you have any bandages and maybe some whooping cream? Because it's chafing real bad. It hurts real bad." He came with a different style of cross-examination, and he went soft with this witness, and and she schooled him with the detail. Every time he would mispronounce a diagnosis or a condition, he got the time wrong. He just little details, and she was catching him on the details. It was interesting. And then he asked the question that let her get in the thing she wasn't allowed to say when Mr. Jackson was asking her on direct. So he opened the door to that. He's only got himself to blame as far as the testimony goes because he asked the question. But it's pretty funny. He took a different tone about halfway through. Like at the beginning, it was sort of condescending. Yeah, thank you. Yeah, 6 minutes. Yeah, that's nice. That's nice, dear. But after she's like, "You're pronouncing it wrong," that's still not what it is. Whoa. She did take full advantage of the soft approach. Wow. Dr. Laposada is trending number 6 on X, which I rejoined because of this trial. We still have Dr. Rentschler. Dr. Rentschler, you're going to see a very, very different Mr. Brennan. He is going to go for the throat on Dr. Rentschler. I think he's able to. First of all, he hates ARCA, right? Brennan hates ARCA. And he's going to go hard on Dr. Rentschler. And he thinks he's got something he can win as well. He's got this study that says it's actually not recommended to use crash test dummies for determining, if the accident would cause these types of wounds because the surface of the arm is different. The material's different. The vinyl's not the same as the skin. That's his ace in the hole card with Dr. Rentschler, and he's going to use that to full effect. You'll see him come out swinging with him. What was the motion for ARCA this morning? Was it for ARCA? I don't think we had an ARCA motion this morning. It was this doctor. Yeah, Brennan. I think Brennan lost that cross-examination, and that's probably the worst he's ever had during this case, during this trial. All right. There's a difference between having sympathy for the family and feeling bad for them and going through what they're going through, what they continue to go through as a court case goes on and on and on, especially in public eye, and how we view the evidence. If you view the evidence as not credible, if you view the prosecution as unjust or not fair, that's not saying anything bad about the family. That's not being insensitive to the family. A conviction, regardless of who it is not just, or that's not justice for John O'Keefe. Yeah, lots of jurors were writing down when Laposada said it did not hit him. It is sad when we see cases that that are never able to be solved. I know there are plenty of cases where we've seen a defendant.
All right, so jurors, rather than keep you here while we do things, I'm going to excuse you for lunch.
Oh, we're going to do things.
Lunch will be about
What
15
sidebar was
minutes
that?
or an hour, and when you come back, we will go straight through the afternoon. We're going to do everything we need to do now.
We're getting it all done. Okay, so it's going to be an hour lunch for the jurors, but it's a working lunch for the lawyers. Can't believe we're on day 30 of this trial. Seems much longer, right? Let's see. That was sidebar number 8, right? 7?
Maybe seated.
All right, Mr.
All right,
Brennan.
so, Mr. Brennan, if you can briefly tell me what it is you want to introduce through this witness.
To remind the court, on direct examination, the defense promoted Dr. Lapasada's credentials, including specifying her successes with the station nightclub fire and her running of her office. I have an audit from 2005, State Department of Rhode Island, Department of Health. In that audit, it paints a very different picture than was presented on direct examination. In that audit, they investigated the chief medical examiner, and they compiled the history of statistics for the medical examiner, which was Dr. Lapasada. There were no reports, incomplete reports, and unsigned reports of over 1,500 individuals between June 30th, 2000 to June 30th, 2005. So in that 5-year period, there was an extraordinary number of individuals that weren't properly attended to, showing negligence, if not malfeasance. It was recommended that the standards, policies, and practices of Dr. Lapasada's office would need to change because of the extraordinary backlog of cases regarding autopsies. In addition, it was noted that the incomplete reports confirmed that there was significant concerns with the historical management practices of the medical examiner's office shortly after Dr. Lapasada resigned. In addition, it was promoted that in the station nightclub fire, Dr. Lapasada had a heroic effort, and in her testimony she also noted that there was a failure, or implied there was a failure because the medical examiner or somebody did not go to the scene to look at the turf in front of 34 Fairview Road. She suffered the same criticism for hours and hours after the station nightclub incident. She was contacted with a request to come to the scene. She refused to come to the scene, did not appear for at least 17 hours, directly on point to the claims that she's making against other people is the same conduct she engaged in on a more extreme scale. She testified in Commonwealth v. Tompkins. In Commonwealth v. Tompkins, she was listed and testified as an expert, attempted to testify as an accident reconstructionist, which was denied. Inevitably, the court made conclusions. Actually, in that case, her efforts to be an accident reconstructionist were denied. Then she testified in a case called Patino. And in Patino, after testifying, she received great scrutiny and criticism from the court. The court noted on page 1025 of the transcript, when Dr. Lapasada gave the testimony, she knew the boy wasn't like this because he fell off a bed. She knew the mother was lying. She read the text messages and knew the defendant had beat the boy. The only reason I conclude that she offered such testimony was to distance the defendant from causing those bruises, setting up an argument against malice, but instead destroyed her credibility. On cross-examination, she came across as a hired gun. Sometimes it's seemingly small things that impeach a witness's credibility. Inevitably, on the credibility determination by the court would agree The jury gave greater weight to the testimony of Dr. Gilson and Snelling than they did Dr. LaPosada for the reasons I addressed previously. The jury was justified in discounting her testimony and concluding the other doctors testified apparently impartial. While she appeared as a paid advocate, at least on this occasion, without impugning the witness's integrity, because that witness is known to the court, but in this case, when she testified, she was not credible. That's a direct credibility determination by another tribunal about her testimony. So I would like to, and that's why I came sidebar rather than ambush, to give the court notice that I'd like to get into the criticisms regarding her run as medical director that led to resignment after she was audited and left 1,500 bodies unattended or incomplete. Also get into the criticism she received for her handling or lack of handling of the station nightclub fire, and finally get into the adverse credibility determination in the Patino case.
So I'm not familiar with the Patino case. So I'll need a copy of that.
Yes.
All right, Mr. Jackson, I'll hear you.
Thank you, Your Honor. First of all,
Come get your stuff, Brennan.
Mr. Brennan said that the audit established that, as the chief medical examiner, the audit revealed that she left 1,500 bodies unattended, was his quote. Bodies unattended. That's absolutely not what happened in that situation. It was a political situation. The medical director for Rhode Island came in and took over. He began to change protocols and cut quality control. He said he did not want a second set of eyes on any of the reports, not the autopsies. There was never a suggestion, ever, that an autopsy was not performed efficiently and timely. Never. The reports that were attendant to the autopsies it was a two-tiered set of criteria that Dr. LaPosada put in place to establish quality control and quality assurance. First, the medical examiner conducts the autopsy and writes a report. Then the doctor herself, the chief medical examiner, because she is a perfectionist, determined that she was going to establish a protocol in which she would put eyes on every single report. Hundreds and hundreds of reports per year. In doing so, she had to prioritize which reports were going to take a priority, which ones were being subject to litigation, which ones were going to be subject to criminal cases, and which ones were never going to be subject to any review at all. For instance, if somebody was found, let's say somebody that was without family, etc., found and unidentified, there's no litigation attendant to that report, she would put that report aside and get to that report after she dealt with the reports that were on sort of on the front burner, if you will. After, by the way, none of the reports were ever not done. They were all completed. There were a small fraction of reports, according to the audit and according to Dr. LaPosada herself, that had to take a back seat. When the medical director came in 2005, by the way, this is 25 years ago, right? These are autopsies that were performed, and the audit was performed for autopsies and reports dealing with the year 2000. It's 2025. This is 25 years ago. When the new medical director came in for Rhode Island, he said, I don't want any review of any of the reports because it's more efficient and it's faster to get the reports out in a timely fashion. She resisted and said, I will never, ever, and she was published saying this, I will never, ever sacrifice quality for speed. I want the highest quality coming out of this office. They had a difference of opinion. She walked away because he was asking her, the new medical director was asking her to sacrifice quality of the conduct that she was undertaking as the chief medical examiner for the state of Rhode Island. So it's a very different circumstance than was just suggested. No bodies were ever left unattended, ever. Certainly did not involve the other phrase that was just used is negligence and malfeasance. It was a backlog, and they had a very public political fight over it. Number two, with regard to the station nightclub fire, her staff was on location immediately. She, as the chief medical examiner, was there the same day. So that's of no legal moment. It's of no consequence. It certainly has nothing to do with her opinions and conclusions in this case. The Tompkins case, we've already talked about that in voir dire, Your Honor. The Tompkins case dealt with an issue dealing with accident reconstruction, which she's not undertaking. I'm not asking her, and she ain't saying.
I've excluded that part of it, based partially on the Tompkins case.
Right, and I don't know anything about the Patino case, and what I would say is, given the fact, look, we don't know what the facts of that case were. We don't know what the trial was about. We don't know what the cross-examination was about. We don't know why she was called. We don't know what she looked at. We don't know why she was looking at what she did look at. We don't know why she didn't look at things that she might not have looked at. We don't know why her opinions and conclusions were ultimately rendered. We would have to have a trial within a trial, which I would be happy to undertake if someone gives me a file. Happy to do that. But I don't think we want to do that. I don't think the court wants to do that. Also, I will say, I don't think that attacking this witness's credibility is in good faith by the Commonwealth. Mr. Brennan himself has hired Dr. La Posada personally no fewer than 4 or 5 times. Maybe it's 3 or 4 times. He knows her qualifications. He knows the quality of her work. He's actually undertaken to consult with her as a medical examiner and a consultant. So I don't believe that these last 2 issues are in good faith. I don't believe the station fire has anything to do with anything, because she was late, according to Mr. Brennan, in coming to the actual location. She was there the same day, and she had an entire staff that was there immediately. And in terms of the audit, it's a 25-year-old political fight that isn't quite what Mr. Brennan made it out to be. So I don't think any of these things are relevant for cross-examination. I'll submit.
All right.
I just want to make a note that Attorney Jackson has a way with words to just inflate or make things up. I have not hired Dr. La Posada 4 or 5 times. And so that is just a mischaracterization which he likes to do for the public. But the reality is, I've used her a few times, and the last time I used her, I'm not going to disclose why I don't use her anymore, because it would be unfair without her in the room. But the suggestion that somehow I'm endorsing the qualifications of this witness, I am not. That's what I'm going to say on the record.
Okay. So the first 2, the backlog issue, if we can call it that, with the ME's office, I'm going to allow the Commonwealth to get into that through questioning. Same with the station nightclub fire, based on the testimony already in evidence. Those 2 areas, and Mr. Jackson, without leading, you can certainly go back and rehabilitate her. But those 2 will come in. I'm not going to do anything with Tompkins, because I used it for the basis of keeping out what appeared to me to be biomechanical engineering opinions of this witness, and she's not qualified to do that. So I have not read Patino. I will read it over the lunch break and see if we get anywhere with that. Okay, so I need a copy of that. I want you to give Mr. Jackson a copy as well.
I will.
Okay?
He has a copy.
Okay, so, all right.
The only other thing, I don't know if you want to handle it now or after lunch or later, but I want to address the issue of the 3.
Okay, so let's mark those now.
Sure.
Wow.
Can we mark them all as 1 A, B, C?
I have no preference one way or the other. It's just 3. They're all
Mr. Jackson, if you can I just see it?
Of course.
Just hold up the size.
These are gigantic x-rays.
ID, yeah.
Mr. Brennan says, Mr. Jackson has a way with words. I did not hire her 4 or 5 times. I have used her a number of times, but I don't anymore, and I'm not going to tell you why, because that would not be fair. It's like, okay, so was it 2 or 3 or 3 or 4? What's your objection here? Got a couple sides in there I need to add to. Give me 2 more. I'm enjoying this level of ASMR. Another sigh. That's 3 I need to add.
H, quadruple H, and I, through I.
Oh, all right. All right.
4H is now entered the
Mr.
chat.
Brennan, there's no objection to these coming in through another witness, so you agree that they'll be coming into evidence?
I'll stipulate
All right. And what's the objection to them coming in through Dr. Laposada?
it's not part of her report or opinion. She's gone beyond her report, talking about the fact that she's studied x-rays and given an opinion. I think that suffices. It really, I think, is beyond the scope of her testimony to begin with. I'd be gracious with it. Stipulate these, I'm sure Dr. Wentz would utilize them if stipulated.
So you'll stipulate to them prior to Dr. Rentschler?
I will.
So you can use them with Dr. Rentschler?
I expected that I could because he certainly used them in his analysis and opinion. But I should be subject to the entry of evidence in the defense case in chief. I understand I can use them in Dr. Rentschler's testimony, but I want to use them with Dr. Laposada. She's a medical doctor.
Would you
consider them for purposes of her opinion? I cannot understand.
So what do you want to ask her about them?
Are these the X-rays that you reviewed? Yes, that's it. That's
Okay.
it.
Okay. So go ahead.
If that's all he's going to ask, I won't have a problem.
Okay. Yeah, I have no problem with that in that form.
That's it. Literally, these are the X-rays that we talked about a little bit earlier. Yes. This is the right hand. Yes. That's the arm. The forearm. Yes. That's the upper arm.
All right. So they're cumulative, but if they're coming in anyway, I will let you put them in.
Thank you.
All right. So the last thing is Dr. Rentschler. I need to hear argument from both sides. I have a new PowerPoint. So I'll hear both of you. Mr. Brennan, I'll hear you on your motion.
We've received the most recent update to Dr. Rentschler's PowerPoint. There are some additions, different analysis in that PowerPoint. This is within 24 hours of him testifying. There are opinions on page 6 and 8 of his May 7, 2025 report. And there are a number of numbers that we have objections to. Dr. Rentschler just generally shouldn't be allowed to express opinions and conclusions about what he thinks about the case or about other witnesses.
All right, so I'm looking, I think, at the new,
Do you have a copy of the new one?
from today, page 6. So what I have are just photos with measurements, so I don't know what the testimony that corresponds with those. I've read, obviously, the report of Dr. Rentschler from May 7th. That does not seem to detail everything, and that's no criticism. I'm just saying it's a scant report, so I don't know what the opinions are regarding these.
I'm sorry. Yep. Please.
I didn't want to speak over Mr. Brennan, I apologize. I just wanted to let the board know that we're talking about after now. We went through, based on Mr. Brennan's suggestions last night, and significantly edited the entire thing. Literally every single slide that you had a problem with. There were a couple that we just really left, but it's very clear.
I see that a lot of the hearsay has been removed.
Okay.
And I can identify this report as helpful.
Thank you.
I'm sorry?
I can identify this report as helpful, the ones that were changed.
All right.
It made streamlines.
So what do you both, I'm going to hear from Mr. Brennan first. What are you objecting to as the report now stands?
I have a most recent copy of the report now. So 9 through 27
Slides 9 through 27 or pages?
Slides 9 through 27 now have Dr. Rentschler identifying and attempting to match different abrasions with different holes in Mr. O'Keefe's sweatshirt. And so basically what he is trying to do is to suggest that there are a different amount of abrasions relative to the amount of holes, or perhaps he might want to testify about that the holes in the sweatshirt were in a different place on Mr. O'Keefe's arms than the abrasions. The reason why this is concerning is because there is no background for him regarding fabrics. This is a different and new opinion that we have not prepared or obtained an expert for. We probably have very little time to get somebody to rebut this analysis regarding fabrics. I don't see anything in his CV or his history that allows him to equate the number of holes in fabric with the number of abrasions on somebody's arm. It does not consider or account that there could be multiple wounds from one hole, or there could be holes that don't create wounds. So whatever the implication is going to be by Dr. Rentschler, we're not very sure, but it obviously would require some type of expertise, which I do not think that Dr. Rentschler has a foundation for. So those are 9 through 27 generally, and then specifically, I can run through quickly the individual objections I have. Slide 6 tries to define the theory of the alleged incident. Doesn't say whose theory it is. It implies it's the government. It's an improper suggestion.
Hold on. Okay, so which one of 1, 2, and 3 on 6?
1 is objectionable. What's the core issue of the case? It's an ultimate issue for the jury. An expert reconstructionist or a biomechanical engineer shouldn't be defining the core issue of the case. And then 3, first event is alleged contact between the rear of the Lexus and Mr. O'Keefe's right arm. Again, that's offering an opinion that doesn't have facts and evidence, not in a position to draw that opinion.
And is 2 okay? Or are you moving to the whole slide?
No, on number 6, all 3 of them shouldn't be there. Asking what the core issue is in the case, Dr. Rentschler and no expert should be defining what the core issues in the case are. They should talk about their training experience, any testing, observations, evaluation, and then give their opinions, not core issue in the case.
All right.
Slide 9 outlines perhaps his process. The first step of the analysis to determine if the arm injuries are consistent with the physical evidence. Evaluate the abrasions and compare the evidence. I suppose this is what he's done. This is one of the less offensive ones, although unnecessary. It doesn't provide an opinion. I could live with that. The next one.
You could live with what?
Number 9.
Okay.
Number 23. Again, this gets into that new core opinion about trying to identify or, I think, compare the abrasions to the different wounds. I think the part that's objectionable is the words measurements, question mark. I'm not sure if it's implying failure of somebody else. It seems to be an opinion, and I'm not sure of the context of it. 24. The expert is trying to define what Dr. Welcher had done. It may be that he's saying he conducted his testing based on the position of Dr. Welcher's arm. I think that would be an appropriate comment, but it's not clear what they're saying. The pain transfer test, number 2, is the only test noted with respect to the arm.
So without the text, are you objecting to this slide?
No.
Okay.
31 posits questions regarding ultimate opinions. I think it's inappropriate. And then 32 I think, is improper because it ultimately endorses or vouches for the witness's credibility. I think he certainly can give an opinion that the evidence is inconsistent with the injuries to Mr. O'Keefe's arm, but I don't think it should be on the slide bolstering his opinion.
Can't tell you how excited I am for this huge PowerPoint presentation.
33. Again, it's posturing the weight of the evidence. And it's resigning the government to a particular study, one study. It's really a commentary on the government's case. It goes like this. Number one, Dr. Welcher only did A, and second part, A is insufficient. So that's really what this is saying. It's commentary, it's hearsay, it's inappropriate. 34.
It's hearsay? Did you say that was hearsay?
I think if one said that that's what he did, I, Dr. Rentschler, took a step to determine the kinematics of Mr. O'Keefe's arm during the alleged incident and asked how would this arm move, I think that would be appropriate. But he shouldn't be giving an opinion on what steps should have been taken by Dr. Welcher. Number 2 on slide 34. And number 3 I don't have a problem with.
So what are we up to? I think we've got 3 slides now that are going to be allowed.
The next one is 46. Again, this is bolstering the expert's opinion by putting it in writing on a slide. I think some of these opinions are appropriate for Dr. Rentschler to share with the jury, but his final ultimate opinion shouldn't be endorsed on a slide. 47. Again, this is self-endorsement of the success of his tests and giving his opinion about his success. Number 1 and 2, I think, are inappropriate. Number 3 has really no context standing alone. And number 4, if he notes that's his next step, I wouldn't have a problem with number 4. Slide 54. Again, number 1 gets into his opinions. Number 2, he gives an opinion about a different expert, a medical opinion. And number 3, it's, again, self-endorsement on his own opinions. So all these are opinions either bolstering himself or somebody else's work. I don't think it should be in a slide. 55. I think it's accurate. I think it's proper testimony. I don't think it's proper for a slide. Same with 56. I don't know that he has the basis for number 1. Number 2, I don't have a problem with on slide 56. And number 3, again, it's bolstering his opinion. So I think 1 and 3 are improper. 2, not. Slide 58. I don't know what the basis for number 1 is. I suppose we'll have to see. If these are Dr. Rentschler's views, I don't know how they're relevant to the Commonwealth's case, but certainly I think he has the experience to make these conclusions, but it shouldn't be in a PowerPoint. He shouldn't be commenting on the reports of another expert in a PowerPoint, number 3. And number 4 is ultimately an opinion that he's self-endorsing. 66. Again, it is an opinion. I don't think it's an admissible opinion, and it shouldn't be in the slide.
We are nearly done. A couple more pages.
Trying to draw a conclusion on what the jury should conclude based on the Commonwealth's evidence. He's not in a position to do that. 67. Parts of this are objectionable. I think that he certainly could testify. He hasn't seen any simulation by Dr. Welcher, but posturing it about in a manner that suggests there should be doubt in some way is inappropriate. 68, I don't think Dr. Welcher's report was introduced. And putting in a fraction of a report, I can't appreciate the significance of it. It's hearsay. Perhaps there's a reason he'll be able to point to the report or talk about the report. I understand that, but putting in a random page from a report is hearsay. Should not be admissible. I don't know if there's going to be a conversation about trying to introduce the entire report, but one page will take it out of context.
Mr. Brennan doesn't want his own expert's report.
72. I think the expert has a basis for the opinion. I don't think ultimate opinion should be in PowerPoint because it's self-endorsing. 74. Again, it's a conclusory opinion. It's bolstering. Some of these can be said but shouldn't be in PowerPoints. Same thing with 75 and 76. They're ultimate conclusions. And so I'm not in agreement with all of the conclusions that the expert may try to introduce, but testifying about an ultimate opinion and putting it on a board to self-endorse shouldn't be permitted. And those are my objections.
Okay.
Briefly.
Ms. Little?
Briefly, Ms. Little.
First of all, if I stand here only because I'd like to be able to reference the PowerPoint.
Yeah, that's fine.
Thank you.
I'll turn it up for you.
First of all, there were no additions, just to be clear, to the PowerPoint. The only changes that we made were directly in response to the objections that were filed by the Commonwealth. We did delete a large section to try to accommodate some of their concerns, as well as shorten some of the opinions and conclusions. So those were the only changes. I just wanted to make clear to the court there are no additional opinions that have been set forth in the PowerPoint. With regards to slides 9 through 27, that was not one of the issues that was identified in the Commonwealth's motion. They objected to slide 9. There's half of those slides are not referenced.
I do agree. It's a new objection. I just don't know when there's an objection raised how a biomechanical engineer is qualified to testify to tears in clothing.
So this is a direct test. His testimony is going to be based on his knowledge of forces and forces applied to certain objects and how that results in injuries.
And I understand that, but some of the specifics that he says, I'm just saying I had a concern, so I understand it's new.
I think that we'll be able to satisfy the court's concerns by laying the proper foundation for him to listen.
All right, so we can come back to the fabric argument or whether it's beyond his scope of expertise. But actually, Ms. Little, if I can just ask you, and I can hear you later, as I assume everybody wants lunch and we're coming back in at about 20 of, quarter of at the latest. Can you just explain to me why these slides, if Dr. Rentschler is permitted to express these opinions, why we also need them on slides? That's the problem I have.
I think that's a great question, Your Honor. And the reason we didn't do these on slides is because we objected to Dr. Welker's coming in on his PowerPoint.
So I looked at that yesterday.
A copy of this specific opinion that was placed up on the screen with regard to his opinions and conclusions. That was done over the defense's objection.
So which one? Because I did look last night at that and did not see it.
It's slide 136, Your Honor. The totality of the evidence.
Hold on 1 second. Is it a conclusion page?
I don't know.
Hold on.
But it's page 136. It's entitled Evidence Brief Lexis Ictonic, and it's states the totality of the evidence is consistent with the right rear corner of the big 2021 Lexus impacting the gunman and Mr. O'Keefe, striking the rear posterior aspect of his head on the frozen ground.
Okay.
So if he's allowed to do that,
So that is different than what I said he could be asked on his ultimate question, right? But it still came in? Was there, I'm sorry?
Over objection.
All right.
Mr. Alessi.
Because what I did note is that I was very careful to say exactly what the ultimate question could be from Mr. Brennan. In fact, there were objections. I sustained them twice, so I wrote out exactly what could be said. And Mr. Brennan asked a variation of the first one, and there was no objection. So I didn't remember that this came in. All right, so I will take a look at that. What I would like to do in the interest of time, so maybe we can talk about that in the conclusion page, but where he outlines everything else, there's so many pages with text that I may not have a problem with testimony regarding this, but why do we need testimony and text so much here?
this is to assist the jury.
It's what?
This is to assist the jury. There is a significant amount of information that needs to be relayed.
Okay.
It's an 80-page PowerPoint.
Okay.
This is solely to make sure that this goes efficiently and effectively. I think it's helpful for these. We've narrowed down the text on the slide significantly. It's important to see those PowerPoints.
Okay.
Just to the major issues. I think we've streamlined this a lot, but I think having the PowerPoint will allow us to make this go smoothly and quickly.
All right, so I will look at these. What I'll try and do is if there are any changes in the first 15, I'll try and get those done during lunch, and then we can have this argument afterwards.
Thank you, I appreciate that.
All right. All right, we'll see everybody no later than 11:15.
All right. If you guys have missed today thus far, yeah, can you hear me? Echo, echo, echo. Hello, hello. How about that? I can't get this thing to turn off. I got it. I figured it out. All right, if you missed court thus far, you have homework. You need to watch this. You need to see what went down today. The arguments, the back and forth, the spiciness, the oh my goodness, Dr. Loposada, I can never say her name right. Incredible on cross-examination, corrected Mr. Brennan all the way through it. Every time he made a mistake on pronunciation of conditions, on the time, on everything. And he, I think at the end, basically went with his tail between the legs to the judge saying, I got spanked on this one. Can I please drag in something that makes her look dirty? Because it did not go my way. And the judge said, sure, go ahead. Yeah, that'd be great. But Mr. Brennan, on cross, on redirect, Jackson's going to be able to cure that. So, wow. What a day. We only have like 20 minutes for lunch. I'm sorry, you want me to talk more?
I'm curious.
We heard you laughing watching the video, some comedy show, and I'm thinking, oh, I wonder what she's watching. Now it's time for me to go to lunch, and she comes in here and says, please catch me up on everything I missed when I was watching my comedy show. I will catch up on lunch. Is that okay? Yeah, this is an incredible day. It's ramping up. This is a crescendo moment in the court case where it's building and building and building. The stress is there. Mr. Brennan is well aware of the jury and how they're feeling about everything. He's paying very close attention to that. Defense is aware as well. The judge is getting, she's antsy. She wants to see this finished, and we're very, very, very close. So we're going to go to lunch. We're going to come back and get more spiciness because Mr. Brennan is going to get to talk to Dr. Loposada.
So what was that with the whole, that he went through every single slide? Welcher had like a 3 billion slide thing. I don't understand. What's the problem with slides?
Mr. Brennan doesn't like slideshows when they're from the defense. So that's what his objection was. So we'll see what the judge rules on those. Yeah, Cesare, I think she knows what's going to happen. Nope. How would you know? Nobody knows. Nobody knows. She's clairvoyant. All right, we're going to see you after lunch. Come back. We've already got a portal set up, so we're going to bring you over as soon as it's time. We'll bring you over, and we're going to continue this afternoon. Tonight, when you go home, please talk to the people you love. Smile at someone to make their day just a little bit better. And please stay safe. We'll go live again in 20 minutes. It's barely enough time for me to get a bathroom break. All right, 20 minutes, and we're gonna get some lunch. We'll be back here in a little bit. See you guys in a little bit. Bye-bye.